With the lordship permission, may I mention one matter? Lordship permission, may I mention?
Yes.
Well, no, item number, it's not, your lordship will not see that list. It's in the hearing list, which I has told it doesn't come to your lordship. Part two, item number 428 and 429. That list is prepared by the registry. That is valid from 14th of July 2025 to 29th of August 2025. So our item is 428 and 429. It's a criminal appeal. The petitioner, there is some other 2018 matter. The petitioner is an SP, and there was a case against him, some custodial beating. So ultimately, that was convicted, and it was 323, 325. It was converted to 330, and we have filed appeal against that order. So he is verge of now, your lordship, of nomination, zone of consideration for IPS. So if it is not inconvenient to your lordship, my lord, so can this matter be upgraded, because it is not here, to any date which is convenient to your lordship, my lord?
This up to Mr. 14th of August, we have all we have fixed many matters.
11th.
It can be after that 15th August.
18th. So can it be, if it is not the 18th of August, Tuesday, if it is possible for this court?
18th. In 19th, keep fixed with you. There are many matters I have fixed because 2012, 13 matters. I have seen in the list. So I have fixed all many. You don't know.
Or 26th, my lord.
Okay, 26 years. Okay, let us fix it on 26
26th.
August.
I am deeply honest.
I can get a little.
May I please, your lordship, I beg to mention to criminal appeal, my lord, to come up for orders for condemnation petition, my lord, in case of IA, my lord.
Give it to the court.
On Monday, my lord, on Monday.
We'll fix the date.
Must oblige.
May please, lordship, for listing regular bail application, lordship.
Regular?
Bail, lordship.
Regular bill? We don't.
The criminal bench, lordship, the senior bench, lordship.
No. Bail matters are not listed here.
Deputy.
No, please, I beg to mention for listing of a criminal petition, your lordship, on Monday, your lordship, because on,
Motion?
yes, motion, your lordship.
Motion?
Motion.
Okay.
Monday.
Wait, listen, I beg to item number 22, my lord.
20?
2, my lord.
Yes.
May this pass over for the day, my lord, and take
Okay.
next week.
On the prayer of Mr. M. Hussain, Learned Counsel for the petitioner, the case is passed over for the day.
Oblige.
This matter may be listed for motion on Monday, my lord, one matter. And another one is for admission. This is regarding area maintenance, my lord. It is pending since May 2024.
Motion to review on Monday. The admission matter will be decided by
May I please, lordship? I beg to mention item number 20, lordship. Matter will
item
be
number
20.
20, yes.
Matter will be kindly be taken up next week, lordship.
Okay. Your name, please.
MS N. Borua.
On the prayer of Ms. N. Burwal, Learned Counsel for the petitioner, release the case in the next week.
Oblige.
On the date to fix by the office.
Please, your lordship. Lordship, I beg to mention listing, my lord.
Huh?
Listing of a transfer petition, my lord, on 11th August, lordship.
Motion?
No, admission, my lord.
Give it to the court master, he'll fix the date.
Oblige, lordship.
May I please, your lordship, I beg to mention item number 4. Your lordship, this item may be taken next week, your lordship.
Okay, on the prayer of Mr.
A. Rahman.
A. Rahman, the counsel paying for the petitioner, release the case after a week on the date to fix by the office.
First place. I beg to mention one criminal petition of fresh motion, my lord. Next date is in the lower court, my lord, on Monday, my lord, 4th of, my lord.
Monday.
My lord, maybe.
Not Friday,
My lord,
Monday.
may I pray for tomorrow?
Why you have waited? Monday.
May it please, your lordship. I pray for listing of a case in orders column, your lordship. Urgency is that NBW is issued and the revision is pending here, your lordship.
Give it to the court.
May it please my lordship, item number 32. My lordship, IA has been filed on 28 July, but inadvertently it got listed on code number 16 as item 63 today.
Make a mention there.
Yes, my lordship,
I cannot take out the IA from that code.
my lordship. My lordship.
Daily list for withdrawal. Item 1.
Withdraw.
Yes, lordship.
Miss
N. Borua.
N. Borua.
I'm paying for respondent number 2, my lord.
Okay. Miss N. Borua, learned consultant of petitioner, Mr. R.J. Borua, learned additional public prosecutor for the respondent number 1, State of Assam, and Mr. R.S. Mishra, learned counsel for the respondent number 2 are present. Post of Ms. Borua, learned counsel for the petitioner has submitted, on instruction, that the petitioner wants to withdraw the criminal petition. Post of both Mr. Borua and Mr. Mishra have submitted that they have no objection to the prayer made for withdrawal. Also, in view of the above submission made by Ms. Borua, learned counsel for the petition, the criminal petition is dismissed on withdrawal.
For motion, item number 2.
May I place on lordship, my lord. I have challenged the conviction dated 2012-2024 passed by Judicial Magistrate Baksa, my lord. In this case,
With the trial court order,
trial order, conviction order, case 13, my lord, annexer 1,
page 13.
1-3, my lord.
How many petitioners here?
Only one petitioner, my lord, is a victim of an,
Jujumoni Gayon.
my lord, improper
Jujumoni Gayon.
convicted under section 447.
Rahul Nath.
Yes, my lord.
He was accused.
I am the complainant, informant, victim girl,
Informant.
against the conviction, illegal conviction.
So let us see that for what the accused was convicted. 447-323.
Only, and acquitted illegally under section 354, my lord. In respect of materials is there available, even CCTV is there.
1 minute. Where is the appellate court judgment?
Appellate court judgment phase started 17, my lord.
Preliminary objection, my lord.
Huh?
I have a preliminary objection, my lord. Let him satisfy whether this petition is maintainable or not, my lord.
Or 1 minute.
My lord, because
Let us come to page 14. Let me understand. This is the trial court.
Yes,
court.
And charges framed were under 447, 323, 354.
Yes, my lord.
Right?
Yes, my lord.
Okay. Then what is the operative part? Operative part?
Operative part, my lord, points for decision case
Is
9,
convicted under section 447.
447 and 323 only. And
Is have an order to undergo sentences as follows. Fine 500 in default 7 days. Fine 1000 in default 10 days. So this was rendered on 2024. Now, why revision?
revision, my lord, of conviction is imposed.
Let us see, do you have the BNSS?
There are sections for conviction, section 447, I will say.
Yes, Mr. Borua, what is your ground for objection?
I have objection, my lord. Here, petitioner is a informant, my lord.
So basically victim.
Basically victim, my lord. Now, my lord, she is aggrieved by this order, my lord. And her prayer is to, my lord, enhance the, my lord, conviction, my lord.
Where is the appellate part in the BNSS?
BNSS 2,
They have filed this, my lord, under section 390.
397, my lord, which says High Court or any session judge may call
Okay.
for and examine the record of proceeding before any criminal inferior
Now-
court instituted, my lord. It will supervise.
Now it is
supervised revision, my lord. I have right to approach before this Honorable High Court under section 397. CRPC, my lord.
397 CRPC. Now we are in BNSS,
Yes, my lord.
right?
Yes, but in case the same, I have the rights. Honorable Court is to scrutinize whether judgment passed accurately or inaccurately, conviction is just or improper.
What is the equivalent provision of section 374 in BNSS?
415, my lord.
415.
BNSS.
No, 374.
374 CRPC, my lord.
It will be 415. 415.
My lord.
Now let us read appeal from conviction.
We have to t-shirt that's nothing like a t-shirt, if
the accused, convicted
I am
accused.
the victim, I am the woman.
1 minute. 1 minute.
My lord.
If suppose the accused prefers an appeal,
My lord.
like he likes to prefer an appeal, which court he would prefer the appeal? From the judgment.
I am not filing any appeal because I come under revision.
Please understand. Please, I am asking you a
No.
question. I am asking you a question. Please answer to that.
374.
374.
Yes, ma'am.
374. Let us understand 374 also. Where the appeal would be preferred. If the accused wants to prefer an appeal against his conviction,
I have two options, my lord. It will appeal also lies before session judge or before session judge, my lord. But
only session judge.
session judge, my lord.
Only session judge.
But
Right?
in case of
Only
original
session
petition,
judge.
my lord.
Only session judge.
Yes, ma'am.
Under section 374, subsection 3.
Yes, ma'am.
Right?
Yes, ma'am.
Now come to 372, section 372 of CRPC. Read the proviso. Let us hear all together. 372.
Yes, ma'am.
Provided that 372
Victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused, convicting or lesser.
acquitting the accused.
Yes, my lord.
So he has been acquitted of the charge under section 354.
Yes.
Right. Let us read further. Such appeal
Lies before the session judge.
to which an appeal ordinarily lies against the order of conviction of such court.
Ma'am.
So, when a statutory appeal is provided under the law, now it has been incorporated as section 413 of the BNSS.
Yes.
So, the question raised by the public prosecutor seems to be correct.
But my lord,
Maintainability
I have come with other.
cannot be. What
What
cannot be done directly cannot be done indirectly. When their appeal would lie against this judgment before the session judge, why should we entertain a revision petition?
So I may be allowed
It
to
is
go
up to-
and refile it.
That is what I was trying to convey you.
Yes, madam.
But you started saying
Option is
something.
also there, madam. But I come.
When an appeal, it is appeal. Appeal is broad-based. It can go into the questions of fact and law.
My lord.
Revision jurisdiction is very limited. When appeal is provided, no revision lies. So,
I may be allowed to and file liberty.
That should have been the first submission.
And secondly, my lord, even if the appeal also, my lord, he have to prefer under BNSS, my lord.
Huh.
Because
Okay.
trial is conducted under CRPC, man, that is no doubt, my lord. Judgment
But
also passed.
BNSS also same thing, 413,
Yes, 413.
section 413.
413.
All right, Mr.
Bhushan.
B. Hussain, learned counsel for the petitioner, and Mr. R.J. Borua, learned additional public prosecutor for the respondent number 1, State of Assam, full stop. The instant revision petition under section 397, Code of Criminal Procedure 1973 is preferred against a judgment, an order dated 2012-2024, passed by the Court of Language Chief Judicial Magistrate Baksa at Mosulpur in case number PRC-60/2021. Full stop. In the trial of PRC so-and-so, case number so-and-so, the accused charges under sections 447, 323, section 323 and section 354 of the Indian Penal Code were framed against the accused and by the judgment, an order dated so-and-so, while the accused person has been convicted for the offenses under section 447 IPC and section 323 IPC, he has been acquitted from the charge under section 354, IPC, full stop, para, agreed by and dissatisfied with the acquittal of the accused person from the charge under section 354, IPC. The petitioner has preferred the instant revision petition, full stop, para. Mr. Hussain, learned counsel for the petitioner, has submitted that in view of the provisions contained in section 4 okay. 41 413, Bharatiya Nagorik Surakha Sanhita, 2023, within brackets earlier, section 372, Code of Criminal Procedure 1973, bracket close, read with section 415, within bracket 3, BNSS, within bracket earlier, section 374, within bracket 3, CRPC, an appeal lies, and therefore, the petitioner wants to withdraw the instant revision petition in order to prefer an appeal before the appropriate appellate court.
Well, saving the limitation period.
It is definitely section 14 you invoke.
Well,
Section 14 is Limitation Act is there.
well, section 14.
Wrong forum, pursuing remedy wrong
Yes,
forum.
my lord.
Full stop. In view of the above submission made by Mr. Hussain Leonard, Council for the petitioner. This revision petition is dismissed on withdrawal, with the liberty, reserving the liberty to the petitioner to prefer an appeal before the appropriate appellate forum.
Item number 3.
Yes,
This regarding a NI case.
NI Act,
Not-
revision petition means
My appeal has been dismissed.
trial court.
Trial court.
Trial court convicted. Who is the judgment?
Page 51, Lordship.
Page 51, trial court.
Trial court, Lordship.
Let us see trial court, page 51.
Annex 3.
You are the accused.
Lordship.
Pratap Das, Madan Baro. Okay, check amount
Check amount 4 lakhs, Lord.
4 lakh.
Lordship.
Where is the operative part?
Page 72.
So you failed to pay. I have heard. Probation. Pay 6 lakh.
Lordship.
Three months and 6 lakh.
6 lakhs.
Okay, then appeal,
Appeal is.
judgment,
Page 94 is the operative, Lordship.
74 is the appeal,
Page 94 is the order, Lordship. Operative portion.
amount out of the so and so. Affirmed.
Lordship.
So 3 months remains.
Out of 6 lakhs, 1 lakhs 20,000.
1 lakh 20 given.
Lordship.
4 lakh 80 is still there.
4 lakhs 80. Lordship.
Yes. And why this is to be interfered with? What ground?
I have taken.
Show me solid ground. Solid legal ground.
So I have taken the grounds that.
You have taken. Show me.
Lordship.
Tell me.
So one thing is that the complainant could not prove his capacity to funding me, Lordship. And,
Did you raise those?
Lordship.
Did you raise those points?
Lordship.
Through cross-examination?
Lordship.
So then, capacity to finding how it will be affecting the judgment.
And my lord, I have also another plea that I have given the check to one Jyotish Sharma, Lordship.
Notice?
Jyotish Sharma, Lordship. One different person, Lordship. And he has also filed a case, Lordship, against me, Lordship.
Against for what ground?
For under section NI.
NI. One check.
No, 2 checks, Lordship, and I have taken the plea that 1 check has been taken by this Pratap Das. He has filed this instant case, and another check, Lordship, is Jyotish.
And that point has been discussed.
Discussed, Lordship.
Okay, then
And otherwise, my lord, in my court,
appreciation of fact is now closed.
Lordship. But I have admitted that, my lord, the signatures in the instant case over the check is mine, Lordship.
Mine. Then presumption is there.
Lordship.
Then how did you rebut it?
Grounds, Lordship, I have taken before the trial court.
No grounds. Then how much you want to pay of remaining for 4,80,000?
25%. 25%.
That amounts to what? 4,80,000, remaining 4,80,000, 1,20,000.
Lordship.
Yes, Mr. Borua, what do you say? Right, I am sorry.
Also,
Just
we made a
because-
party, Lordship, I have spoken. Party, you are stating a party.
Copy is not served to us.
It is a party.
Party.
You assist the court what to do in such situation. 4 lakh was the check amount.
My lord.
3 months punishment sentence plus 6 lakhs. Now in the appellate court, during the appellate proceeding, he paid 1,20,000. So out of 6 lakh, now it is 4,80,000 remaining.
My lord.
Right? So there is no legal point. otherwise
my lord.
to admit. What do you suggest?
Without admitting, when a notice can be issued, my lord.
Huh? Notice issued, but what about this? Because there is a provision in the NI Act also. Let us see, NI Act. Because he is facing imprisonment.
Not 3 months.
He might be taken into custody any day. Which part? 148.
142.
No, 148, NI Act. Mr. Fukan,
That's,
there is no Indian prayer.
no, I have filed different IL also.
I.
25%, my lord. He can deposit 25%, my lord.
Direct 1,20,000 more.
My lord.
1,20,000 more
150 more, my lord. That can be done.
within a period of
3 months, Lordship. 3 months,
statute does not say so. Statute says within 60 days
Lordship, 10 to 60 days, Lordship.
before the registry.
Lordship.
Hard. What is the point? Some point should be there, otherwise we are very difficult. Though not legally tenable. You adduce defense evidence.
Lordship.
Let us see your defense evidence part.
Page 40, Lordship.
Page 40.
May I read, Lordship?
Yes.
Lordship, on oath. Jyotish Sharma was my friend for several years. In the month of December, I borrowed rupees 3,50,000 from Jyotish Sharma in 3 different installments. Jyotish Sharma, I had to pay rupees 3,70,000 in total, including interest to him. On 12th January 2016, I gave a check for rupees 3,30,000 to Jyotish Sharma and the amount credited in his account. I could not pay the remaining 40,000 to him for few days. On 21st April 2019, Jyotish Sharma came to my home and asked
Heard Mr. R. Fupan Learned Counsel for the revision petitioner and Mr. R.J. Borua, Learned Additional Public Prosecutor for the respondent number 2, State of Assam, full stop. The petitioner was the sole accused in the criminal proceedings of NI case number 38 of 2021, instituted by the respondent number 1, herein as the complainant. Within bracket, respondent number 1, that's complainant, for short. Under section 138 of the Negotiable Instrument Act, in the Court of Learned, Additional Chief Judicial Magistrate, Borpeta. Post. After conclusion of the trial, trial court bracket. The trial court had convicted the accused as petitioner for the offense under section 138 NI Act, and he has been sentenced to undergo, a rigorous imprisonment for a period of 3 months and to pay a fine of rupees 6 lakh. In default of payment of the fine amount, to undergo simple imprisonment for another 2 months. Post. The complaint case NI case number 38 of 2021 was with regard to dishonor of a check issued by the petitioner accused in favor of the respondent number 1 as complainant for an amount of rupees 4 lakh. Post of. When an appeal was preferred against the judgment and order of the trial court, the appellate court of Learned Additional Session Judge Borpeta dismissed the criminal appeal, case number 23/2024 by judgment and order dated 7/4/2025, thereby affirming the judgment and order of conviction and sentence passed by the learned trial court. First up, in the judgment and order of the appellate court, it is mentioned that in the interregnum, the accused petitioner had deposited a sum of rupees 1,20,000 out of the total amount of fine of rupees 6 lakh. Post up. Para. Mr. Fukun, Learned Counsel for the revision petitioner, has submitted that the learned trial court as well as the learned appellate court failed to consider and appreciate the evidence adduced by the accused petitioner. Post up. I've gone through the statements and affirmance made in this revision petition. The revision petition is admitted for hearing. The case records of so and so and so and so be called for from the trial court and the appellate court. Issue notice returnable in 4 weeks. As Mr. Borua, respond number 2, then the accused petitioner shall take steps for service of notice upon the respondent number 1 that's complaining by a registered post with AD as well as by usual process within 3 working days from today. However, the appeal is admitted, subject to the conditions imposed in the order, subject to the condition, the terms and conditions set forth in the order dated, same date, passed in the connected accompanying interlocutory application IAC number so and so. I লিখিব এতিয়া। এইটো এনেকে লিখিব that hard so and so so and so. This interlocutory application is prepared by the applicant who is the petitioner in the connected revision petition, comma, seeking suspension of the sentence passed against him by the learned trial court of so and so in NI case number so and so, which is subsequently affirmed by the appellate court of so and so in criminal appeal number so and so. After para, he can repeat for the way to Takakini. A 120 level, 120 level to 1,20,000 out of 6 lakh Indian, part of the a defense part to the Hindu, appreciate. Having regard to the positions made and considering the comma, this court finds that the applicant petitioner has made out a privacy case for suspension of the execution of the sentence passed against him and for his release on bail till disposal of the accompanying criminal revision petition. So, it is therefore provided that subject to deposit of an amount of rupees 1,20,000, which is 20% of the remaining amount to be paid as fine by the applicant petitioner within a period of 60 days from today before the registry of this court, by way of registry of this court, comma, the remaining part of the sentence passed against the applicant petitioner shall remain suspended till the disposal of the accompanying criminal revision petition. Remaining part means 3 months plus the other beyond 2,40,000.
3,60,000. Obliged.
Item 5.
May I plead the lordship?
Yes,
My lord, the issue is that, my lord, whether the trial should commence under the IPC or POCSO Act, my lord. Because, my lord, determination of age, my lord, the section 34 of the
now what is the first? Let us understand first.
Yes,
What
ma'am.
is the FIR?
FIR,
Then only can I can understand. Take me to the FIR.
page 14, my lord.
Ramisha Khaitun Abu Nasser. It is reputed ever so and the aforementioned accused. The case was registered as
Registered as my lord.
448, 376 IPC, read with section 6. Yes, thereafter.
Thereafter, my lord,
Hmm.
uh,
It was in 2024 May. Okay. Then who is Ikram Hussain? Okay, this is arrest. Abul Nasser, you were arrested.
yes, my lord.
Okay. Then forwarding report.
Yes.
Okay. Then what is this page 21? Medical examination report.
Medical examination report.
Okay. Seizure.
Yes, my lord.
Seizure.
Medical
Then page
examination.
26. School transfer certificate.
Yes, my lord.
Date of birth.
Yes, my lord.
Yes, date of birth. 2008. Incident is of 2024. 8. So it looks like within 18 years.
Then, my lord,
Yes.
page 28, annexure 7, my lord.
28. Yes.
Then, my lord, that ossification test was done, my lord. Annexure 8, page 29, my lord.
Formal charge. Yes.
Page 20.
How?
Page 29 is the ossification report, my lord.
Huh.
Which says that, my lord, we are, because on the basis of the application filed by the IO, my lord, the ossification test was done, my lord. Which says that we are of the opinion that the age of the individual is between 18 to 19 years of age, my lord. So, my lord, now, my lord, the provision of the POCSO Act says, my lord,
POCSO Act.
POCSO, section 34, my lord. Where any offense under this act is committed by a child, such child shall be dealt with under the provisions of the Juvenile Justice, Care and Protection of Children Act 2000. So, my lord, if your lordship now takes the Juvenile Justice, Care and Protection of Children Act 2015, my lord, section
Let us
90.
read where any offense under this act is committed by a child. Now come to page 20.
Yes, my lord.
Mohammed Abul Nasar, age 50 years.
Yes, my lord.
You
Yes, ma'am.
took me to section 34, where any
Sir.
offense under this act is committed by a child.
Yes, my lord.
Committed by a child.
Yes.
Committed, not committed upon a child.
Yes, my lord.
Committed by a child means child is the accused.
Yes, my lord.
Now here it is Abul Nasar. His age is 50 years.
Then, my lord, section 2, my lord. Section 2, if any question arises in any proceeding before the special court, whether a person is a child or not, such question shall be determined by the special court after satisfying itself about the age of such person.
Which one?
34(2).
(34)?
2, my lord.
It will come, my lord, the person who committed the crime.
No, my lord.
This is child in conflict with law.
Yes, my lord.
If the accused can raise a plea of juvenility before the court.
Yes, my lord.
But here that is not the question.
My lord, if your lord.
Here the charge has been framed under section 376 as well as under section 6.
6, my lord.
Because the question is about the documents, school certificate or matriculation or whatever certificate, or
Yes.
thirdly, ossification test.
Test, my
And
lord.
ossification test is not exact science,
Yes, my lord.
right?
Yes, my lord.
This has to be plus or minus. That will
Yes,
be
ma'am.
determined by the trial court
Yes, my lord.
after appreciation of the entire evidence.
Yes, my lord. My submission.
So
is that-
why should we jump upon it?
My lord, my submission is that that has not been done, my lord. They have not considered the ossification report, or they have
Not
not
required
examined.
at the stage of,
They
not
have not
required.
examined it, my lord. If your lordship peruse this judgment, my lord, it clearly says that, my lord. Yeah. They have not, my humble submission is that they should consider the ossification report, my lord, and they should come to a finding. Kindly come to paragraph 11 and 12 of this judgment, my lord. Paragraph 11 and 12, my lord. So paragraph 12, my lord. In view of section 34(1) of the POCSO Act, section 94 of the JJ Act 2015 becomes relevant and applicable. That provision is extracted below. So, my lord, the provision of 94 of JJ Act will be applicable. Presumption and determination of age, where it is obvious to the committee or the board, based on the appearance of the person brought before it under any provisions of this Act, other than for the purpose of giving evidence that the said person is a child, the committee or the board shall record.
Mr. Bora, firstly, there is a school certificate, right? And this IO's satisfaction recorded is not the final word,
Yes, my lord.
right?
Yes, my
And
lord.
he has done ossification test,
Yes, my lord.
the medical board.
The court has.
So court will
done-
determine.
The court has done. He
Court has
has
framed.
made a prayer to before the court, and accordingly, my lord, ossification test was done. Report
It
is
is,
there
it is,
before
it
the
is
court.
part of the charge sheet.
No, my lord. Subsequently, my lord, it was prayed, my lord.
No, when it was, charge sheet was submitted. But so far, it is for a court, Mr. Bora. Please come to page 23 and 23. Because as per radiological age, it is between 16 to 18,
Yes, my lord.
right?
That was the.
Seizure- No, Mr. Bora,
Yes,
I'll, if
Yes, my
you,
lord, I understand.
then as per school certificate, it is 2008, date of birth, year of birth. Right? And ossification test, dental and radiological. Radiological was also done by the medical officer. Now they will have to come and depose. Thereafter, conflict in view. This is regarding 94, I can understand.
Yes, my lord.
Section 94.
Because section 94 specifically says that matriculation certificate or birth certificate, and if these two are not available, then
No,
ossification test.
is it for the court, the 482 court, to determine?
No, my lord.
Then
I am not praying for before this court to determine. I am praying that the learned trial court should.
it will do so.
They have not considered it, my
It
lord.
will do so.
The ossification test was done as per the direction of the court. But
Evidence are to be laid on it.
Yes, my lord.
On the ossification test report by the medical board, the medical examination by the medical officer, as well as the certificate. If the certificate is proved to be genuine,
Yes.
after calling for the headmaster and all authorities,
Yes, my lord.
right, that will prevail upon ossification test or medical examination report. That is the law. That court will reach that opinion after appreciation of evidence. We are not jumping on it.
My lord, they have not considered the ossification report, and they have not.
These are to be considered and after the value of those documents, evidentiary value of those documents can be considered only after the parties lead evidence on it.
My lord, my prayer
But
is
this
that-
cannot be as evidence now.
My lord, my prayer is that first that.
Sir, it is not an evidence now as on date.
My lord, my humble prayer is that first that should be decided and then it should be proceeded under.
Then
IPC or
you go to
POCSO, my
the,
lord.
with Juba Prakash, you go to the apex court.
No, my lord, I am praying that, my lord, it should be.
I know,
considered
I am
that-
closing it.
Then it
This
should be-
is,
Then it should be decided where it should. be
this is
proceeded
putting the
under
cart before the horse.
Under the POCSO Act or the IPC, my lord.
Charge has, that is why this law has come into being. POCSO. This is a matter of appreciation of evidence because this medical officer, after radiological test, X-ray was there,
That was the
16 to 18.
initial,
Then thereafter, the certificate which is there,
that was.
IO's opinion is not the final word, sir.
Yes.
IO cannot decide
Yes.
about the age. It is the trial court, special court,
Yes, my lord.
on the basis of law and on the basis of evidence laid during the trial will decide upon the age of the victim.
Yes, my lord. That is my humble. prayer,
Or,
my
yes, that will be decided
My lord, that is my humble prayer that let that should be
because
decided
prima
first, my
facie,
lord.
what is the standard of framing a charge? Tell me.
No, I understand, my lord, but my
What is the standard for framing a charge?
prima facie satisfaction, my lord.
Yes.
Yes, my lord.
What are the laws? Right from 1977.
Yes.
Right from Praful Samal. What are the laws for framing charge? These are to be evidentiary value of these. This doctor is to be called, the documents
That's
of
what I
age
want, my
certificate is to be called.
That's what,
These are-
my lord, they should do that, my lord.
You make an application
We have
that
made,
these
my lord.
doctors, medical so-and-so be called for the trial at first as a,
My,
that's the court will
my
decide.
prayer is that, my lord, they should consider, they should take the evidence on that part and then they should.
Make
proceed.
an application before the
We
trial
have
court.
we have made, my lord, we have raised the contention of that has not been considered by the
Where?
trial court. Before passing of the order dated, impugn order at page 30, my lord, 23/5/2025.
Hmm.
Before passing this order, we have raised that of the contention, my lord.
Hmm.
I am not praying that your lordship may decide on the age of the victim, but the trial court will decide on the basis of the evidence or other material.
When can, Mr. Bora, to me from the provisions of the Evidence Act, CRPC, BNSS, BNS, as on date, whether this report of the medical board can be treated as evidence. What is called evidence?
No, my lord.
What is called evidence? Please tell me.
Which has to be adduced by the concerned persons, my lord.
No, it can be treated. I have, that is why I have named all these
Yes, my lord.
acts.
Yes, my lord.
Show me from the provision that this report of the medical board.
That report has to be proved, my lord. Yes, my lord, I understand.
Yes, yes. From which provision it is to be taken as the final word
No, my
before the trial, before the, then what you are arguing then?
I am not saying that that should be taken as a final report. That should be proved, my lord.
It will be proved, sir.
My lord, but the proceeding will be, my lord.
Then you'll see, you can, you'll argue later on that, oh, charge was not there. Miscarriage of justice. You'll invoke section 464 CRPC. Oh, I was not tried for. So miscarriage of justice, it caused prejudice to me. You know now what are the charges you have to meet or you have to rebut. Now you are quite aware. So you lead evidence, disprove it. establish the document of the medical board and disprove. Evidence Act says prove, not prove, and disproved. All three have been defined. Disprove these two and prove the medical board. And that can be done when it comes and takes the form of evidence. Otherwise, you'll take the plea. It is prima facie view. It is not the final view.
Your Lordship may
Hard.
indicate that I will raise the plea before the learned trial court and they should consider.
Definitely.
Yes, my lord. Your Lordship may
Definitely, you will
indicate.
contest. You have all the opportunity to disprove.
Yes.
But the other two documents, sailing with the IO, prosecution will try to prove or not to prove. This is a different matter. It is a matter of trial, not at this stage.
Your Lordship may.
Linking evidence would be there if it is there, but here it is a ossification test, which is an
Yes,
opinion.
madam.
Opinion.
And my contention is that only.
It is
that they should
opinion.
consider-
As
They should consider and they should take evidence.
final arbiter is the special judge.
Yes, my lord. Yes, my lord. So
And
your Lordship may observe that particular.
but
That they should consider this.
it will be.
Yes, my lord.
You have the right, Mr. As
So
an
we
accused.
raised that issue, my lord, but they have not considered it, my lord.
Heard, Mr. D.P. Bora. I should not have wasted so much time. Learned counsel for the petitioner and Mr. R.J. Borua, learned additional public prosecutor for the respondent state. First up, the petitioner is facing a trial in special POCSO case number 08/2025 before the Court of Learned Special Judge Nagaon. As first up, a formal charge. Sorry. Charges. Sorry, Learned Special Court has already framed charges under Section 448 and Section 376 of the Indian Penal Code, read with Section 6 of the Protection of Children from the Sexual Offences Act 2012 by an order dated 23/5/2025. First off, the charges were framed, were read over and explained to the petitioner as the accused, to which he pleaded not guilty and claimed to be tried. First off, the case had thereafter proceeded to trial as the Learned Special Court by the order dated 23/5/2025 had also ordered issuance of summons to the informant and the victim, fixing 19/6/2025 for recording evidence. First off, para. It was a first information report lodged by the mother of the alleged victim as the informant on 23/5/2024 before the officer in charge, Botodrova Police Station. The case, Botodrova Police Station, case number 448. Sorry, 49/2024 was registered on 23/5/2024. Full stop. In the course of an investigation ensued, the petitioner was arrested on 27/5/2024. And he was forwarded to the court for production on the same date. On being produced, he was remanded to custody. In the course of investigation, the alleged victim was medically examined at maternity OPD of BP Civil Hospital on 23/5/2024. After medical examination, the examining medical doctor had issued a medical examination report recording the findings and the opinions therein. In the same medical examination report, the medical officer, medical and health officer, BP Civil Hospital, Nongam, had recorded a finding that on the basis of the radiological age of the alleged victim was between 16 and 18 years. In the course of investigation, the IO also seized a school transfer certificate in the name of the alleged victim issued by Headmaster Amolki Tetibari, MEM, wherein her date of birth was recorded as 11/1/2008. Giving an opinion. As a birth certificate could not be produced before the IO during the course of birth certificate of the alleged victim could not be produced during the course of investigation before the IO, other than the school transfer certificate, the IO sought for ossification test of the alleged victim for determination of her actual age. A medical board was thereafter constituted, and the alleged victim was examined by the medical board on 5/6/2024. In the findings recorded in its report by the medical board, it was inter alia stated that on the basis of the examinations, the medical board was of the opinion that the age of the alleged victim was between 18 to 19 years of age. On the basis of the above materials, the petitioner has approached this court seeking to invoke the inherent powers of this court, seeking the revisional power of this court under section what is BNSS? Seeking the revisional stroke inherent powers of this court under section so and so, and section so and so, 52828. Take a look at it. Para. The learned counsel for the petitioner, as referred to, section 34(1), POCSO Act, and section 94 of the Juvenile Justice so and so Act 2015, to buttress his submission that the learned special court at the time of framing of charge ought to have taken due consideration of the opinion rendered by the medical board in the report of the medical board poster. Para. As already noted above, the medical board constituted for the purpose of ossification test of the LSD for ossification test of the LS victim. Had rendered an opinion about the age of the LS victim to be between 18 to 19 years of age. So on the other hand, the school transfer certificate indicated that at the time of issuance of transfer certificate, at the time of transfer, seeking transfer by the LS victim, her date of birth was recorded as 11/1/2008. Full stop. In the medical examination report conducted by the Medical and Health Officer, BP Civil Hospital, Nagaon, it was observed that the age of the LS victim was between 16 to 18 years. Post stop. Para. It is on the basis of, at that stage of two 27. At the stage of framing of charge, the special court if upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution in their behalf, considers that there are sufficient grounds. There is ground for presuming that the accused has committed an offense. Then he shall frame a charge in writing. He shall frame in writing a charge against the accused. Full stop. The documents mentioned above, the evidentiary value of the documents mentioned above regarding the age of the alleged victim can be decided only during the course of the trial. Full stop. The documents have not been exhibited before the trial court to, as on date, as on date, for this court to treat the same as evidence. Full stop. The definitions of আজিকালি নতুন এখন ওলাল ন এখন দিয়কচোন এভিডেন্স এখন নতুন এখন আহিছে ন আজিকালি সাক্ষ্য কিবা সাক্ষ্য the definitions of quote unquote document. Quote unquote evidence. Quote unquote proved. Quote unquote not proved. And quote unquote disproved have been defined in the Bharatiya Haikya in section 2 of the Bharatiya Haikya Adhiniyam, 2023. First of all, it is only after appreciation of the evidence laid during the course of the trials before the special court, wherein the accused will have all the opportunity to rebut the charges and to disprove, comma, it is evidently clear that this court, in exercise of its inherent stroke revisional power, cannot decide on the evidentiary value of the aforesaid document for determination of the age of the alleged victim at this stage, full stop, being not merited, comma, this criminal petition, revision petition, is not found is not entertained, full stop, as the petitioner during the course of the ensuing trial can avail all the legal remedies to dispute the age of the alleged victim. No cost.
Item 6.
Your Lordship. Lordship, the cause of action to file this criminal litigation petition, Your Lordship, due to rejection of a prayer, Your Lordship, of Juvenile.
Yes, Mr. Borua.
No, Lordship,
Let us call for a report.
16.
Page number 18, my lord.
Hmm.
Page number 18, last paragraph, my lord.
What is this Asraful business?
Discrepancy is the name, Your Lordship.
Hmm?
Because the by
What is the FIR?
page number, Your Lordship. Particular page number 13, Your Lordship.
At one point of time, it was without number plate.
Number plate. It was a new
Scorpio, right?
Lordship.
Then as per the RC, it has a registration number.
New vehicle.
Then where is the seizure?
Seizure is not new, Your Lordship.
Huh?
Seizure is not new, Your Lordship. There in the
Officer in charge. So this Scorpio was left at the spot.
Lordship.
Hmm? left at the spot.
3 vehicles are alleged to be in.
Sure, yes, I have read it. 3 vehicles, then out of that 3 vehicles,
Scorpio.
this Scorpio was left at the spot
Lordship.
when they fled in the other 2 vehicles. Then let us see the order, impugn order.
Case number 16, Your Lordship. Starts from 16, Your Lordship. The relevant part is at case number 18, Your
From the PO.
Lordship.
And what is this RC? Asaful.
Lordship.
And who is this owner of the vehicle is Asraful? As per verification,
No, what,
Asaful, RC says Asaful.
Your Lordship. What happened, Your Lordship? One
As
vehicle-
per eyewitnesses. No, it says,
Lordship.
let us read the order, then you say.
Lordship.
As per verification, owner of the IO submitted a report. Owner of the vehicle is Asraful, he says. And as per eyewitness, he came in the morning. You are also a suspect. According to IO,
Lordship.
you will definitely claim innocence. Yes, Mr. Borua.
Report may be called from us. There is discrepancy in the name, that is why my trial court rejected the Zimma order.
But if the RC,
Asaful.
Asaful, and why you have made the mistake? Now this petition is for, by what name?
Asaful, madam.
Your Lordship.
Now it is Asaful.
Yes, Lordship. What happened, Your Lordship? One anticipatory verification preferred, Your Lordship, before the Honorable Session Court, Your Lordship. There, Your Lordship, the mistake was there, Your Lordship, in the bail petition. So considering that contention, Your Lordship, the IO has reported the same, Your Lordship. Otherwise, my RC.
Okay, Mr. Kesari,
My lord,
or what?
better will call for a report, my lord. Report, my lord.
Okay.
Whether the
Hard,
matter is
Miss.
Vice Lordship, 23, with due respect, Your Lordship, the 23 June 2025, my vehicle has been seized, Your Lordship. So,
We are aware of all the law, Miss Bora, don't reiterate those laws. G. Bora, petitioner. R.J. Borua, Land Additional Public Prosecutor for a respondent state. First of, the petitioner has approached this court challenging the legality and validity of an order dated 23/6/2025 passed by the Court of Learned Judicial Magistrate First Class Hojai, whereby the petitioner's petition preferred for interim custody of a vehicle, comma, bearing registration 9. And bearing registration number new, a page 17 also. Engine number so and so, chassis number so and so has been rejected. One of the grounds for rejection is discrepancy in the name of the owner of the subject vehicle. Full stop. Placing reliance on a registration certificate, comma, annexed as annexed to this petition, comma. It is contended that subsequently, comma, the subject vehicle has been provided with registration number AS-01 stroke 07927 in the name of the petitioner, comma, namely, comma, Asaful, ASHAFUL, ভালকে লিখিব দেই, Islam. Full stop. It is contended that a confusion arose between Asaful Islam and Asraful Islam while deciding the interim custody petition. Issue notice returnable on 13/8/2023. The land additional public copy invocable. The additional public prosecutor shall obtain a report from the IO of what police station?
Jamuna movement.
So answer case number IO. Jamuna Mukh.
My lord.
Jamuna Mukh police station case number 13/2025. Full stop. As regards the registered owner of the subject vehicle having engine number, chassis number. Full stop. Para. The petitioner is at liberty to submit copies of the documents related to the subject vehicle before the IO within 7 days from today.
Ship, not GO, not GO, GZ, Lordship, registration
Z?
number.
Z.
Lordship.
Okay, Z.
Item 7.
May I please, Lord?
Yes.
Lord, the FIR, my lord, page 13, my lord.
You are Kharpatu.
Accused number 1 in the FIR.
Kharpatu. Yes.
An FIR filed on Nirmal Kaur, my lord. May I read, my lord?
And there was restrainment to cultivate the land
Lord.
By the accused persons. Manpreet Singh sustained injury, informant sustained injury, then 126. What is 126? Comparative sir, BNS code. BNS, that's a BNSS. BNSS, 156. BNSS. 126. Secret for keeping peace in other cases. 118. Discharge a person informed against. What is 118?
Voluntarily causing hurt by.
Voluntarily causing hurt. Oh, IPC. Okay. BNS. BNS ko nai no?
74, my lord.
Enaka bonwa nai na? Getting confused. 126.
126, my lord, wrongful restraining. That is bailable.
1 minute. সেইখনো বনাব লাগিব য'ত BNS আগত আছে সেইখনহে লাগিব এতিয়া লাহে লাহে BNS 126
126.
wrongful restraint
Lord.
then voluntarily causing harm
Lord.
and what is 74
74, earlier 354.
354
Earlier 354, now 74. Assault.
okay assault now 74
Now lost.
okay yes
Then this FIR.
and these are bailable non-bailable
My lord, 118 is non-bailable.
118
Lost it. And 74 also non-bailable now.
118 non-bailable
74 also non-bailable.
okay 118 causing hurt it is non-bailable
Non-bailable.
then 126
126 bailable.
bailable then 74
Non-bailable.
so 126 is non-bailable
Bailable.
bailable 118 is non-bailable and 74 non-bailable okay
Now, this case was registered, my lord, on 28/6/2025. Then the dispute, my lord, regarding a dispute between two sisters regarding share of their land.
but there is assault is there
But assault is there. The petitioner, my lord, I have, my lord, entered into agreement for parcel of the land with the accused number, mother of the accused number 2. In this regard, my lord.
now for what you have come
Now, my lord, on 19/7/2025, the IO, my lord, filed an application before the learned judicial magistrate, my lord, for issuing non-bailable arrest of warrant against me, my lord.
so
And on
if
this,
it is non-bailable did you seek any bail
my lord, we have filed bail petition, my lord. It is also listed today.
so if you're granted bail this goes
No, my lord, because once, my lord, NBW issued, my lord, until it is cancelled or executed, it will remain in force.
but what is the why this is illegal
Lord,
legality and validity
thereafter, my lord, the impugn order has been issued, my lord, page 29.
yes you are challenging the legality and validity
Lost it.
on
Now,
what count
my lord, before the case is, my lord, initial stage of investigation. Police did not serve, my lord, notice. Although, my lord, in the application, he said that notice was served. Notice was not served upon the petitioner. Just 29.
what is the provision
Now, my lord,
I'm not aware of this BNSS non-bailable these are non-bailable police has the power to arrest
my lord,
without warrant or what is the law laid down
without warrant, my lord.
what is the law laid down otherwise
My lord, regarding non-bailable warrant, my lord, this Honorable Supreme Court, my lord, guideline, my lord.
show me
And similar situation arose, my lord, in Delhi, my lord.
let us see provision similar situation
Provision, my lord, 74.
let us see first
Of the
section 35
NSS.
41
Notice.
Now, why he is resorting to that?
This is, my lord, in collusion with, my lord, the informant, my lord, who is, my lord, some.
Don't bring collision first, legality and validity.
Yes, otherwise.
Don't bring all this,
Because otherwise.
all this which cannot be decided.
Within 19 days of, my lord, FIR, police did not take any step for arrest, although he has.
Don't bring collision angle first. Tell me the provisions.
35, my lord, police has jurisdiction.
All those can be sang for 1 hour, 2 hour. Legality, illegality, collision, connivance, all this can be said for 1 hour, 2 hours. Tell me the legal provision
Well, Section 35.
which
my lord,
cannot be
lordship.
decided. Tell me that why he has resorted to.
35.
Once again, let us see 111.
35, my lord.
Let us see 118.
118. BNS.
Cognizable. Then 126, you said? 126. 126. Sorry, 126. To cognizable, reliable, and 74. 74.
Subsequently, 109 was also added.
109.
Lordship.
What is 109?
Attempt to murder.
Attempt to murder.
307.
Yes.
This is also non-bailable and non-cognizable offense, my lord. One 118 also cognizable, my lord.
Mr. Borua,
My lord.
prayer for issuance of warrant of arrest.
My lord.
Earlier it used to be 73, I think. Now it is what?
74.
74. Let us see 74. This 75, see, the Chief Judicial Magistrate or a magistrate of first class may direct a warrant to any person within his local jurisdiction for the arrest of any escaped convict. Escaped convict, he is not escaped convict. A proclaimed offender, he is not proclaimed offender. Or of any person who is accused of a non-bailable offense and is evading arrest. When?
During murder investigation.
When this part, evading arrest, is satisfied.
My lord, when, my lord, that is why, my lord, I'll just show one line, my lord. Page number 28, Annexure 5, my lord.
Oh,
My lord, second paragraph, last line, my lord.
second paragraph.
Page number 28, Annexure 5. Second paragraph, last line.
That is what I thought. Yes.
The part
I
number-
already read 35.
Yes.
In the
It is
meantime.
already served, my lord.
Served.
Served.
Served 35-3. That is what I read. $35,300. Are you denying it?
Lordship, I am denying, my lord.
How?
It has not been served, my lord.
Not served.
No, my lord.
You will run a risk. I'll stay. Call for the
Record.
case record
CD,
and heavy cost.
Lordship.
Heavy cost. We'll call for the case diary.
The police, my lord, when.
Because the police officer shall in all cases where the arrest of a person is not required.
Lordship.
Under subsection 1, issue a notice directed to a person against whom a reasonable complaint has been made to appear before him or at such other place as may be specified in a notice. Now, at two places at page 28. Further, notice under section 35(3) BA and SS has been served, but both of them does not comply with the notice and evading from arrest. Then, ground 3. The FIR named accused persons are not cooperating in the process of investigation as the notice and the so served, but they did not comply in evading from police.
Lordship.
Take your call. I'll fix it on a date so that I remember everything.
Lordship.
You may run the risk of 50,000 also. Clear cut. If it is abuse, then abuse. No point. Till then, I'll stay. Categorical statement. Where is it is made? Where is the statement made?
But there is some typical error, my lord, in paragraph 8, my lord.
Paragraph 8.
Lordship.
Okay.
Police went, my lord, without, my lord, female police. There was none, only.
No, you are male, perhaps.
Lordship.
Is
No,
it
no,
not?
This is, my lord, revision petition against the warrant, my lord.
Huh? Yes. And this man, Chauhan, he is a male person. Harpatu.
Lordship.
Huh. Now, therefore, the police, then what is this statement? What is this statement then? Paragraph 8.
Paragraph 8, my lord.
Family members.
Lordship.
Now, let us
They went
see
to
how someone is to be served. As per the BNSS or
notice.
service.
35(3), my lord.
35(3) notice.
Lordship.
Notice is as good as summons. 35(3). Let us see.
The police officer.
Right, a person against whom?
Cases where arrest of person is not required. This section, so is notice directing the person against whom the reasonable complaint has been made. Directly to the accused.
Now let us have section 64.
64. Someone. (64)(2), my lord. The summons shall be practicable, be served personally on the
That will be,
person.
my lord, in respect of my lord.
1 minute, 1 minute. Yes. Then read 66.
66.
6. That female thing is gone now. Male female thing is gone. Yes, Mr. Burra.
No, my humble submission, my lord, that 66, 64, my lord. It is pursuant to the summon issued by the courts, my lord. Appearing attendance of.
That I know. Now tell me, is there any provision for serving notice?
No, serving notice also for that purpose also was to go to, my lord, 103 of BNSS, my lord.
103 of BNS.
My lord.
Okay, good.
That's
103 BNSS. This is SARS.
SARS, my lord.
Huh.
Because my lord, they are searching.
Which subsection? This is SARS.
SARS, my lord, because my lord, lordship may kindly peruse the order, my lord, that they have impugned, my lord. That this person, my lord, stating thereby that the IO has made several attempts to arrest the accused person, but they are absconding and deliberately avoiding arrest. RDIO, peruse the case diary placed by the IO. I have also gone through the search list under section 103 BNHS. Take with the case diary. That is, my lord, they have searched
So-
the house, my lord.
Search the house. Attempts to arrest.
Because, my lord, since my lord, the 35
Then
notice,
this is
they have not complied 35 notice, my lord. Then thereafter, my lord, IO searched their house, my lord.
so but your averment says it has been served 35(3). 35(3), your averment paragraph 8. You are saying
This line, my lord, subtitle error is there, without, in place of without, my lord.
how can it be, sir?
On affidavit.
How can we? It is an affidavit.
without-
Therefore, a police by serving notice on the so-and-so to the
That
family
would-
members.
that
Now
would
that,
be fine.
that submission you
Lost.
mentioned,
Lost.
that female, that is gone now.
Lost.
Earlier CRPC it was there, male. Now it is gone.
Lost.
It includes female also. Then 35(3). Thereafter, if he has made an application, there is, the challenge fails with your averment.
Lost.
And with, now if you still categorically say, then the cost will be involved. The cost will be involved. Now, if you still say categorically that no notice was served, we'll call for the case there, you will stay the order,
Lost.
but it will run the risk of 50,000. Take your call. Take your call. Because saying wrong making wrong submission will entail cost. And if your thing comes to be true, I'll stay this order. But later on, it is found to be false, cost. What do you say? Propose.
Yes, my lord.
You will get a stay.
My lord.
You will get a stay. On the basis of submission made by Mr. Ali. But otherwise, legality and validity, questioning, that false. No merit. Because there is a statement and your statement also.
Even, my lord,
Let us see 135 again.
35.
35(3) again. Initially, their intention was not to arrest you.
Lost. 35(3).
35(3).
Thereafter, entire,
Oh.
my lord, entire, my lord, game has
But
been
when
saved.
such person complies and continues to comply without notice, he shall not be arrested.
Lost.
Right? But if fails to comply
Then, my lord,
or unwilling to so and so, police officer may subject to such orders as may have been passed by a competent court in this behalf. Arrest him for the offense mentioned. He has an abandoned precaution. He has went for section 74. Take your call and come back. I propose we can put it on Friday or Monday.
Lost.
If you are successful there, end of the matter.
lost,
You'll get bail.
lost.
I think this is the best way. A law may not be favorable to you, but justice may.
Lost.
Let him be.
My lord.
Their anticipatory bail.
Lost.
You may get it, then it will be redundant. I think that is the best way.
Lost.
We put it on Monday.
Lost.
Okay.
May Lordship, I'm appearing on behalf of informant Lordship. Today we are going to file our Vakalatnama. Today we are going to file our Vakalatnama Lordship.
Extended is not party here.
Heard Mr. R. Ali. You'll assist the public prosecutor. And Mr. R.J. Burwal and additional public prosecutor for the respondent state. Miss S.
Yes, sir, Khalifa.
Khalifa, Learned Counsel, has submitted that she is going to file power today for the informant and would assist the learned additional public prosecutor in the proceeding. Also, as sought for by Mr. Ali, lays the case on Monday. You proceed there. Lost.
Item number 8.
May I please, my lord?
Hmm.
My lord, this one application, criminal revision petition, and it is a check bouncing matter, my lord. My lord, both the court,
Enact.
trial court as well as the appellate court.
Enact.
Yes, my lord, enact.
Hmm.
My lord, the appellate court.
Check amount
Check amount was 5 lakhs.
5 lakhs.
But the accused.
Trial court judgment?
Present petitioner was sentenced to pay a sum of rupees 4,35,000.
Where is the trial court judgment?
My lord, the trial court's page 69 is the relevant portion.
Page 69.
Page 69 starts from the judgment.
4,35,000 fine.
4,35,000 in the last paragraph. The
In
convict
default,
also,
2 months.
in-
Then appellate
in default-
court.
In default SI for 2 months. The
Appellate
my lord,
court.
we have preferred the appeal and the appellate courts, my lord, page 69. Sorry,
Hmm.
but
Upheld.
appellate court page 86.
Upheld.
Upheld.
Hmm.
My lord, here.
There was
the-
compromise.
My lord,
There was compromise.
there was compromise,
But
but
you could
during
not-
pendency of the trial, a settlement agreement was reached between both the parties. Thereby, the present petitioner accused agreed to pay a certain sum of money, but he has again failed to pay. So, my lord, the legal point here in this case, my lord, with all respect, I submit that when there is any settlement agreement between the complainant and the accused in respect of the payment of the money, then the original NI Act cannot be continued. At best, as per the Honorable Supreme Court's the decision, the original settlement agreement subsumes the original complaint.
Let us see.
Yes, my lord, I have enclosed here. In my petition also, I have mentioned, my lord,
Show me the judgment.
my lord, at page number 11 of my petition, the relevant portion I have mentioned as a ground number 4. It
you
starts
have the
from page
copy of
number
the
10, my
petition?
lord.
Do you have a copy of the judgment?
Copy of the judgment.
Because picking one line from a judgment will be difficult. Yogendra Pratap. Subodh so and so reported in so and so. If the registered notice sent to the Supreme Court further gave ruling. Page ground.
Ground number 4, my lord, page number 10, for that the evidence on record reflects that a petition bearing number so and so dated so and so was filed during trial of the complaint case whereby both the parties settled the matter amicably and complainant respondent number 2 accepted the proposal of the compromise with the petitioner accused whereby the accused has agreed to pay sum of rupees 4,10,000 in 10 months. And the same fact has also been reflected in the judgment dated 7/3/24 passed in CR case number so and so at paragraph 24 of the judgment. That is the trial court judgment, my lord. After amicable settlement, the petitioner paid the part of the compromise amount which was accepted by the complainant, and that being the actual position, the settlement agreement subsumes the original complaint and the proceedings cannot be continued once the matter is mutually settled. And as such, the entire proceedings of the CR case number so and so was vitiated after 09/12/2019, and the petitioner accused cannot be convicted, but both the learned courts below totally ignored this law point, and the learned appellate court also passed the impugned judgment mechanically, whereby the conviction was upheld. I have mentioned here the judgment that the.
Do you have the copy of the judgment?
Copy is not available right now, my lord.
Without reading it, how can we
My lord, though I have mentioned.
decide on the point?
Yes, my lord.
Because otherwise the complaint will proceed.
Yes, my lord.
Compromise is arrived at during the pendency of the proceeding. then if the complainant, sorry, accused has the intention to defraud, after paying that, there is a compromise, so, and then it goes. And this should be in all cases.
No, that is the.
That if that is the logic,
Yes, ma'am.
Honorable
That
Supreme
is
Court
the
has
normal
arrived at,
procedure
then we'll
I-
go by it, we'll
Yes,
go
ma'am.
by it.
My lord.
We'll go by it.
Yes, ma'am.
We'll follow the Supreme Court judgment, but let us have the facts earlier
Well,
of that case. Gimpex Private Limited, Manoj Goel.
Monday.
Because logic otherwise, NI case filed, proceeded, then accused will come, I'll give you double the amount. Okay, complainant,
My lord.
enticed by that, arrived to a compromise agreement. Oh, take 5 lakh, I'll give you 10 lakh. Signed. Accused as an advance gave 1 lakh.
My lord.
9 lakh remain to be paid. Then NI goes
Yes, sir.
and accused does not pay. Then civil law, money suit for 9 lakh, 10 years. It is
Yes,
to
sir.
obviate the civil remedy,
Definitely.
long remedy, the enact has been, otherwise it has a color of civil,
My lord.
but it has been made a criminal offense. Now, if this is the logic, then enact should not
My lord, this is. one
Should
of
not-
the
should
grounds
not be-
made In my.
should not be a statute which should remain.
Grounds are also there, my lord. Another groundsman says, my lord, entire matter was
It was
wrongly
all
taken into consideration.
Gimpex, Zimpex. No, we are also learning.
Well,
We are also student of law, but logic defies.
Gimpex Private Limited versus Manoj Goel.
Logic defies, but if it is the law, then we'll go by it. Because Ase, Gimpex. Manoj Goel, right.
Manoj Goel.
You should have come armed with the judgment. Because here is a case,
My lord.
concurrent finding of fact, trial court, appellate court, both have reached a concurrent finding of fact, right? And they have recorded that amount is there, and whether they have referred to the judgment, Manoj Goel, the Gimpex, in the judgment, no reference. CCs have mentioned.
No, but perfect.
Otherwise, deposit 25%.
My lord, there are certain other grounds also, as I mentioned in my petition. Ground number 2, my lord.
Because we're not going to touch otherwise legality.
Law point is also involved. my
Law
lord.
point.
Apart
What is
from
law
this-
point now? This is one law point.
Yes, my lord.
One,
Another point, my lord, just, my lord, at ground number 2, I have mentioned
tell me,
that,
what is the law
it
point?
is the violation of section 142B, subclause B of the NI Act. This is so the complaint must be made within 1 month on the date on which the cause of action arises under clause C of the proviso to section 138. When the cause of action arises, yes. My lord, in this particular case, I have mentioned as a ground, page number 7 of ground number 2, that a complaint case so and so, the statutory notice under section 138 was sent to the petitioner by registered post on 30/03/2015, 30th March. But no acknowledgement was submitted by the complainant side showing the actual date of service of notice, and to this effect, there was no evidence on the record also. In the respondent number 2, my lord, gave the evidence that he did not receive back the acknowledgement card. And on 10/4/15, the petitioner made a mobile telephonic contact with him and he reassured to return the money within a month. And further, the petitioner requested him not to file the case.
But
My lord,
judgment, section 27,
yes, my lord.
General Clauses Act, and interpreted by Al Hadi or something,
30 days.
CC Al Hadi or something.
No, yeah,
Then you have to
Allah, the
rebut.
judgment is there, my lord.
27 is rebuttable.
30 days is
The standard of rebut.
my lord, after 30 days, even I am entitled to get 15 days time. So as to make up my mind to pay the amount. So it means 45 days must be passed once the notice is issued. But here, in this particular case, the case was filed only on.
Just a minute, let us
My lord,
have this. Gimpex. Para 24 1 minute. That is what the law. There the first proceeding was initiated for dishonor of a check. Compromise agreement was arrived at. As per the terms and conditions of the compromise, the accused issued another check. That check also got bounced. Both proceedings continued. Right? So both the proceedings cannot continue parallelly. The second set of check it gave rise to a fresh cause of action attracting liability under section 138 and other remedies under civil law and criminal law.
Yes.
So second should continue. Fresh cause of action. First case, compromise. Accused issued another
Yes, sir.
check.
but my lord,
Then that got bounced. The complainant initiated another proceeding.
so a
both-
separate
both-
court of action was
both-
created here.
Both went parallelly. Then Supreme Court said the first one cannot continue because another phase of cause of action because of the compromise agreement.
Yes, ma'am.
Then attracts 138 as well as criminal law, civil liability, all. Second one. That is not your case.
My lord, my case
That
is,
goes.
my lord,
Then
my lord,
what legal point?
my lord,
In the context of CC Alaji,
my lord,
let us count.
my lord, page 7 of
The legal
count
point
number
false, the amount to be deposited will increase
my lord,
because it goes down. It will go up. I propose 25. The second point falls 50%. Tell me. Because it is concurrent finding of fact. First point goes.
Yes.
Next.
Second point, my lord. My lord, ground number
Tell me the
two, ground number two of my
Tell me the
application,
date.
page 7.
Tell me the date. Date of sending the notice.
My lord,
Date of sending the notice.
my lord, date of sending the notice, registered post on 30/3/2015.
30.
30/03/2015.
Where is the document?
And the case was filed on 30/4/2015,
30.
just after 1 month. 30/04/2015.
What is the evidence?
And my lord, when acknowledgement card is not received, even after the notice is sent
No,
by way of the
what is the
registered post.
evidence? Let us, postal receipt has been enclosed. Postal receipt 33, okay. Page 38. Where is the point discussed?
My lord, page number 8.
Page number, no, not
Page-
page.
page
Come
eight
to
of
the
my-
judgment.
My petition, my lord.
Come to the judgment.
Page 61.
Okay, page 51.
That
The complainant has averred, right? That you received a demand notice on 10/4/2015. Where is the complaint?
complaint page number 24, my lord.
Page number 51.
It starts from page 24, my lord, complaint petition. As filed by the respondent. He has mentioned in paragraph. In paragraph 5, page number 27 of the complaint petition. In paragraph 5. He mentioned that that he did not receive back the acknowledgement.
Where is the
card.
evidence?
Hello.
Evidence of complainant. You have annexed, that is why. PW1. Pranjum Kulita.
This discussion was made at page number 83, 84. Trial court judgment, page number 84, it was discussed.
No.
At
Where is the
para-
evidence of the
at para number
complainant? Where is
20.
the evidence of the complainant?
Page 30.
Huh?
Evidence of the complainant is
Page
the-
30.
Page 30, from 30 to 39.
Evidence on affidavit. Okay. Now where is the cross examination?
From page 40.
Page 40, cross examination, 40 to 48.
Absolutely nothing. Categorical averment. It was served on 10/4/2015. The testimony. It was not put to question. You made a telephone call. He said, it is in evidence. It is in evidence.
I know.
Absolutely no question on it.
But my lord, if there is any illegality in coming
Other
to
it
a
is presumed to be served
conclusion or the
as
finding.
per section 27 of the General Clauses Act. Now, he said categorically 10/4/2015. So from 10/4/2015, 15 days expired
Yes, my lord.
on 25th or 25th,
My lord, when edit
Close.
card is not here,
50% hard registry, 60 days. I said, untenable point is not to be urged.
Well.
Legal point you have said, show me, did you question the factum of service of notice on 10/4/2015?
Yes.
So yes or no? If yes, show me the.
Yes.
I have read. Absolutely no question. I heard Mr. A.K. Jain, learned counsel for the petitioner, revision petitioner, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 1, State of Assam. Post. In this criminal revision petition, the revision petitioner has laid challenge to a judgment dated 7/3/2024, passed by the Court of Learned Judicial Magistrate, First Class Kamrup M. Guwahati Trial Court in complaint case number CR-1107 C/2015, which has been affirmed by the Court of Learned Additional Session Judge FTC number 3, Kamrup, Metro Guwahati, within bracket appellate court, in criminal appeal number 39 of 2014, in its judgment dated 29/5/2025, post up by the learned trial court. The complaint case was instituted for an offense under section 138 of the Negotiable Instrument Act. Post of the learned trial court as finding the accused, that is a revision petitioner, guilty of the offense under section 138 and Act, has sentenced him to pay a fine of rupees 4,35,000 to the complainant, and in default, to undergo simple imprisonment for a period of 2 months. Post up. The judgment and order of conviction and sentence passed by the learned trial court has been affirmed by the appellate court. Post of para. Mr. Joint Learned Counsel for the petition, revision petition, has submitted that there was a compromise agreement during the pendency of the complaint case, and as part of the said compromise, the petition, revision petitioner had paid an amount of rupees 1 lakh to the complainant. Post of. As part of compromise agreement, the petitioner was to pay a sum of rupees
4,10,000 was agreed to be.
4,10,000 against dishonor of the concerned stake amounting to rupees 4 lakh.
4 lakh.
Post up. In view of default subsequently by the petitioner, the proceedings of complaint case proceeded further, and after conclusion of the trial, the Arnett Court had rendered the above judgment in order of conviction and sentence. First of, in support of his submissions, Mr. Jain has referred to the judgment of the Honorable Supreme Court in Gimpex Private Limited versus Manoj Goel, 2022, 11 SCC 705. First of, para on having perused, it is contended that in view of the compromise agreement arrived at between the complainant and the accused during the pendency of the proceedings of the complaint case, the further proceedings could not have been continued. As the settlement agreement had subsumed the original complaint. Post of upon perusal of the judgment in Gimpex Private Limited Supra, this court primacy does not find any similarity of the case of the petitioner with the said case. Post of in Gimpex Private Limited, the original prosecution under Section 138 NI Act upon first complaint resulted in settlement. Post of the accused thereafter issued checks to comply with such settlement, but the said checks also got dishonored. Thereafter, a second complaint was filed with regard to dishonor of the settlement 6. Resultingly, there were two sets of complaints under Section 138 based on the dishonor of the first set of 6 and the second set of 6, respectively. It was in that background, the Honorable Supreme Court has observed that non-compliance with the terms of the settlement agreement or dishonor of checks issued subsequent to it would give rise to a fresh cause of action, attracting liability under Section 138 and other remedies under civil law and criminal law. Post of it has also been observed that the compromise deed being agreed upon, the original complaint must be quashed and parties must proceed with the remedies available in law under the settlement agreement. Full stop. Regarding Mr. Jain has further submitted that a demand notice was issued on 30/3/2015 and a complaint was filed on 30/4/2015 without there being 15 days, without expiry of 15 days notice period from the date of service of the notice. The complainant who deposed as PW1, had categorically asserted in his testimony that the notice was served on 10/4/2015. We find no on perusal primacy, there was no cross-examination of the complainant by the defense on that point. If the notice was accepted to be served on 10/4/2015, then in the event of filing, sorry, the complaint filed on 10/4/2015 would definitely be after 15 days notice period, post of, be that as it be, post of. The matter would require further consideration, issue note, the revision petition. 50%?
25, madam.
50%.
25, make
I said, I gave a caveat.
Amount already paid may be deducted accordingly.
Surely, surely.
Because some amount was
Surely,
already
how
paid
much?
during pendency of the
How
matter.
much? I gave a caveat.
That evidence
With
says that
present time-
already he has paid 2 lakhs rupees during pendency of the case. Part.
No,
amount.
no, we record, on record.
Yes, madam.
Whatever is on record. Let us see once again the appellate court judgment. You said 4 lakh against 4 lakh, you paid 1 lakh,
Trial court.
right?
Hello.
Appellate court judgment. Yes, Mr. Goswami, where it was observed?
My lord,
2 lakh.
In the judgment itself, it was mentioned. madam.
Upon hearing was the final sanction along with the corrected convict the first time
Page
to
80.
pay to remain in default. As the accused has already paid, hence if the
Page 80.
remaining principal due amount has been kept by the complainant and like 35,000. Trial court, how much? Trial court, how much?
Trial court's direction was 4 lakh.
What is the trial court judgment?
Page 66, lordship.
Operating part.
Page 66.
66, sentence hearing.
Yes. This sentence hearing.
And appellate court?
Appellate court, page 80, lordship. There is a
My lord, page number 66 of the trial court's the judgment.
Hmm.
Page number 26, paragraph 34 of the judgment. Kindly, I may be allowed to
Hmm.
read, my lord. As the accused person has already paid rupees 2 lakhs. Hence,
So
if the
3 lakh has remained.
that
3
is
lakh
the
has remained.
check amount was, my lord, 5 lakhs.
Take
And
out 5
he has already paid 2 lakhs.
Oh, then compromise was.
And out of compromise, some amount was paid.
No, no,
My lord,
no,
I'm not
no.
sure how much amount exactly.
Check was what? 5 lakh. Check was 5 lakh.
Check amount was 5 lakhs.
দেখক আগৰখিনি বাদ দিওঁ সেই এমাউণ্টৰ আগৰ কথাখিনি যে আছিল 4 lakh নেকি but having regard to the findings recorded in paragraph 34 of the judgment of the Learned Trial Court. It is ordered that subject to deposit of 50% of the remaining principal due amount of rupees 3 lakh, that is 1,50,000, by the revision petitioner within a period of 60 days from today. Before the registry of this court. Having regard to the provisions contained in section 148A of the Act, comma, the execution of the sentence, remaining part of the sentence passed against the revision petitioner shall remain suspended and you are on bail.
Previous one.
And
It may be
the
allowed to
petitioner-
continue.
and he is allowed to remain on previous bail.
Previous one.
Post up. The revision petitioner is to place a compliance as to place before the court the due receipt regarding compliance on the next date of listing or on expiry on the 60th date after expiry of 60 days from today. Issue notice returnable in 6 weeks. Returnable in 6 weeks. Petitioner shall take steps and so on and so on.
Item 9.
May I please? Your Lordship?
Yes.
Lordship, we have challenged the impugned complaint as well as the order dated
Impugned order. Where is the impugned order?
18/12/2024,
Page.
page 99, Lordship. Complaint is at page 95,
Propose.
the relevant
named
para is 95.
Are present. Proposed accused.
Yes, Lordship.
Proposed accused Oloka Devi Kakoti is absent. Medical document enclosed, heard allowed are represented.
Having
Copy
heard
is
both
furnished to the proposed accused person, having heard
both sides and from perusal of the case report.
Limited procedural case. There is no legal bar in filing the proceeding of this case. Case will be decided on merit on the basis of the facts found on initial deposition and evidence. 5/4/2025.
Yes.
What is this?
Lordship, this is a complaint, Lordship, alleging that a sale deed was executed between the mother of the complainant and
Mother of the complaint. Who is the complaint? What is the name of the complaint?
Anjana Mohanto, Lordship. Anjana Mohanto Boiso, the
Wait.
mother of the complainant against whom she has.
That the respondent here.
Yes,
Respondent here.
Respondent here.
She is the complainant.
She is the complainant. He filed a complaint alleging that the mother of the complainant and the petitioner number 3 before your Lordship, who is the accused number 3 in the complaint, they executed a sale deed, registered sale deed, fraudulently.
Complainant is mother.
Mother.
She is a petitioner here.
No.
Okay.
She is not accused in the.
Okay, tell me then. If I am able to
She is
understand.
not accused in the complaint. She has not been made as an accused in the complaint. The petitioner.
What is the complaint?
That your Lordship will find at page number 90, starts from page number 92. Your Lordship will find at page number 95 is the relevant portion, para 7.
92.
Starts from 92, para relevant portion your Lordship will find at 95. Initially, she filed a.
1 minute. Let me be, I am not conversant with BNSS. Okay. What is the prayer?
Prayer is to punish the accused person under 61, 61, 2, 74, 79, 130, 111, 314, 318, 322, 335, and 336. So basically, this relates to cheating and.
What is an application of section 210?
210.
Read with 94.
94 is the production of documents.
Document. Now, what is 210?
Is
200. Earlier 200 or what?
200. Lordship.
Earlier 200.
Yes. This is basically a civil dispute, Lordship, which is given a criminal color. Because she initially, the complainant, she filed a civil suit that I have annexed with this petition.
Now, how this proposed accused came?
Lordship, she
What is the procedure now? Is
now
there
the
change in
initial
procedure?
Initial deposition and evidence. The trial court says that it will proceed with the initial deposition.
No. Why this proposed accused person came into picture?
Because after initial deposition, the cognizance will be taken, and then.
No, Mr. Bora, right?
Yes, Lordship. The initial
By
deposition.
this order.
Yes, Lordship.
Case was posted for initial deposition. And before that, appearance of the accused, proposed accused persons.
Yes.
Were secured.
Because of 223.
Let us see. I'm not conversant. That is why I'm.
Because 223 says that before taking cognizance, the accused has to be heard.
Complaint.
But it also says that the
Let me
complainant.
read first.
Lordship.
But the stage of cognizance has not come.
No. Stage of cognizance has not come. Only after the initial deposition will.
Yes.
The cognizance will be taken.
Complaint. Now, what comes first? Complaint is filed.
Yes.
Right. Then
The initial deposition has
while
to be taken.
taking cognizance of an offense on complaint, shall examine upon oath the complainant.
Yes.
Now, which comes first? The
The hearing
the
of the
language,
accused.
how it is to be interpreted.
Because it has to be interfered in my respectful submission. Because
Otherwise, on receipt of a complaint,
Yes.
the magistrate satisfied.
Notice goes to the accused.
No. He takes cognizance upon it.
Yes.
I think if I am correct, and thereafter proceeded to examine the complainant under section 200. Thereafter 202 or 204
Yes.
earlier. Now here it says no cognizance shall be taken without giving an opportunity of being heard.
Subject to correction, Your Lordship, what earlier was provided, the complaint is filed, the initial deposition is recorded, and then the cognizance is taken. Now it says.
If I am not wrong, cognizance is taken on the complaint.
Lordship.
The concept is a bit subtle.
Lordship.
Subject to correction. Initial deposition is recorded.
Lordship.
Right. Then process is issued.
Issued.
Against the person accused of the offense.
Yes. Yes.
But without initial deposition, the cognizance is taken on the complaint.
Yes.
There is some difference.
Yes.
At that time, the process person accused of the offense would not come into picture.
Yes.
Cognizance is taken on the basis of the complaint.
Yes.
If magistrate has to read it, then cognizance is to be taken.
Yes.
Thereafter, initial deposition is to be recorded. Yes. Thereafter,
yes,
the person accused of the offense, sufficient ground,
yes,
that who are the accused, process is to be issued.
yes,
Right?
yes,
Cognizance and issuance, accused are not same.
yes.
Now, I have not understood this.
Now,
While
it
taking
says that the accused can be heard.
Examine upon oath. Yes, proposed person. Yes.
As your lordship says, that the moment cognizance is taken on the complaint, here now says that the moment cognizance is taken on the complaint, the accused has to be heard. And he can produce the documents for hearing. To see whether there is any other material to proceed against the accused or not.
So, by this impure order,
Yes.
cognizance seems to have been taken.
Yes.
Seems to have been taken.
Yes.
That is why he has written, I find sufficient materials to
Material.
proceed with the case.
Yes, exactly.
So, after initial deposition, the accused will be identified, then
Yes.
process will be issued.
Issued.
When is the next date?
It is on 5/8/2025. Now,
5/8.
my only ground is that the material which the learned trial court have perused are not sufficient material to
Okay,
proceed
we'll
with the case.
examine it on before that 5/8.
Lordship,
5/8.
Lordship,
For what?
for initial deposition.
Okay, thereafter process will be issued.
Yes,
Is it so?
on the same day it can be issued because the moment
We think it over. Mister, this is the court. This is a new provision.
This is the new provision, my lord. First, my lord, that my lord, deposition is taken, then my lord, process issued.
Process will be issued after deposition.
Deposition, my lord.
But the giving opportunity to the accused,
My lord.
that and how much he can rebut or what is the opportunity to be given to the accused?
After notice, my lord.
And what is the application of mind required to be exercised by the magistrate if the proposed accused says it is a civil dispute? How much application of mind is
exactly
to make
yes
initially, because there is a civil dispute lying
yes,
with,
yes.
right? So we'll propose again to see. I mean, we will not embark upon without knowing the nitty-gritties. Mr. Bora.
R. Bora.
R. Bora. Petitioners.
Lordship.
That is not a party one.
It's a private complaint.
Lays the case on Monday. Let's see.
Lordship. I'll also read.
Yes, you find out
Yes.
what are the other high court
Other high court says, Lordship.
says,
Yes,
right?
yes,
It is an opportunity to
Yes.
cut short the proceedings.
yes, yes,
I think
yes,
this opportunity has been given to the proposed accused to cut short
yes,
the proceeding. If it is no offense,
yes,
a complaint is not to be proceeded with, I think.
yes.
Let us see what is find out the object and purpose behind this provision.
Yes,
Place it.
yes. Congratulations.
Item 10.
Met visitors.
Yes, Mr. Islam.
In this case, the petitioner is accused of a POXO case, he is facing the trial. After the examination of victim girl, the petitioner has filed a petition under section 3(1) on CRPC and 348 of NSS for re-examine the victim. And that petition was rejected by the learned court below. And this petition has one opportunity given to re-examine the victim girl. There is some point in the suggestion. There is some point was maybe typical mistake or suggestion was not given properly. Page 26 is the petition filed by the petitioner. Paragraph 3, Your Lordship. As per allegation, incident took place inside the house. That if you want to say that he did not inside the house, that suggestion may be some. Post part, page 25, paragraph 14. কি বলিছে what we said inside the room is one এইটো কৈছে the suggestion দিছিল inside the room এই কৈছে I was visit কৰিছে but inside the holy এইটো কৈছে suggestion to this
Mr. Islam, change of advocate,
that's
change of advocate,
that's yes
change of wisdom,
sense of wisdom but what sense
change of wisdom, change of perspective. How can it be allowed?
my your lordship that
This
suggestion
kind of practice is deprecated.
one chance may given for second because they said that
No ground.
we did not visit the inside the room.
Had it been the same advocate,
No,
there could have been a different thing,
different sense.
right? That no, I gave the suggestion in this manner, but the court had recorded. This man was not there. Come to page 27.
Lordship. I also said that why
This man, let us see, heard both sides, Peru's case record. See, it is found that man who asked the question, the learned counsel who asked the question, he did not file the application
another case.
saying that I put the suggestion in this way, but court had recorded the suggestion in a different way. The counsel who filed the petition did not cross-examine the victim. How can he know?
No, as per my instruction, Your
Sir, this is totally.
No, as per my instruction, I also put that question why he is not.
No.
Because he's
Rightly dismissed.
why the Rahman is your.
This change of counsel, change of perspective.
No, as per my instruction,
No.
that why the
That's-
Rahman, that counsel, earlier counsel, he was engaged by that petitioner, counsel, head of petitioner. He was stays, Your Lordship, earlier engaged that counsel was cross-examined, subsequently they have said another report.
See, the reasoning is clear.
This was impugn order is reflected. The trial
The
order
next
is reflected.
counsel, you have engaged a more experienced counsel. He found that no, suggestion would have been put in a different manner. The earlier defense counsel, despite lengthy cross-examination, put a suggestion in a different manner. So how did he know?
As per my instruction, that
No instruction, your instruction will not do.
no,
You were neither the counsel.
junior counsel,
I-
they have engaged.
You were none of the two counsels.
No, junior counsel engaged
No,
that.
everything does not go to your satisfaction. So it doesn't reach your satisfaction, no. Next day, after arriving in your chamber, when you see, oh, no, I should have done it in this manner. So let us file a petition.
One opportunity given Your Lordship for satisfaction. of the
Dismiss with
request.
cost. This is totally irrelevant. You argue in your defense evidence. And what is this? Had not visited my house. Ought to have been, the accused had not visited inside my house.
Incident took
This is totally for delaying the trial.
No difference.
Inside is not put.
Perhaps no difference would be.
No, nothing, no difference.
Incident took
Another counsel, maybe more learned,
Yeah.
inside should have been put. He was not there when the victim was cross-examined lengthily. Oh,
inside the incident took place inside the house. Did not deny that. I have visited, but he's not inside the house.
and Mr. Islam, tell me, in a trial, what is the value of a suggestion?
I think
Tell me. What is the probative value of a suggestion? Maybe a line of defense is indicated.
immediately.
So that can be very well taken in defense examination, defense evidence. You entered a written box. That just because inside was not put in the suggestion, so let the victim be called. Then whatever was left, the more learned counsel will put. This is filling up a lacuna and to delay the trial. Imposing cost, 5,000.
Allow me to withdraw this petition. Allow me to withdraw this petition.
Don't waste the time of the court in this manner. Okay. Heard Mr. S. Islam Learned Counsel for the petition and Mr. M.P. Goswami Learned Additional Public Prosecutor for the respondent state full stop. After hearing the Learned Counsel for the parties at some length on the Mr. Islam Learned Counsel for the petition submitted that the petitioner wants to withdraw the instant payment petition in view of the above submission made by Mr. Islam Learned Counsel for the petition. The petition is dismissed for on withdrawal.
Item number 11.
Mr. Bora, so many motions will be difficult. We'll find a vacant date. We'll find a vacant date in your part.
I'll not.
Interesting question.
Yeah, my lord, definitely the interesting question, but it will be covered by the Balakrishna judgments. What your lordship? Not to
We'll examine that.
At a different date,
we'll examine that. I indicated to you.
Well, yes, I have one that is Tufan Singh is not my
necessary. Not necessary to be relied upon.
That is absolutely so far the Balakrishna is concerned.
That is
question number 2.
Perhaps the question number 2.
23, Article 23.
Perhaps the question number 2, maybe. We'll examine.
My lord.
But you need not have to wait today.
My lord.
We'll find out a vacant date.
My lord.
And thereafter we'll deliver it.
My lord.
Right?
Okay.
Site hobo, it data khali ase, it may di
Maybe
it will be after not up to 9th or 10th. Maybe say probable date maybe 19th. 19th of August.
19, I have an
You have some
engagements because there's another case that I have to argue at a matter. It will take time also on that is on 19.
We'll accommodate.
Yes,
if not possible, we'll
19 will not you keep this matter 19. Second half, I'll do it. Second half. Oblige me.
Yes, madam.
Look, here I have noticed some inadvertent mistake from my prior lordship.
Which one?
Here, this application lordship. Some
Item 11.
Item 11 lordship.
Okay.
So lordship, I pray lordship for withdrawal of the same with liberty to file
File
a
a trace. Okay. Ms. T. Shom, Learned Counsel for the petitioner has submitted that some inadvertent mistakes have crept in the petition. Therefore, the petition may be allowed to be withdrawn, with liberty to file a fresh. Mr. M.P. Goswami, present. In view of the above submission made by Ms. Som, Learned Counsel for the petition, the criminal petition is dismissed on withdrawal, with the liberty to file a fresh.
Item number 12.
Yes,
Peruse the last order.
yes, or an edition was referred the report from the officer in charge for some time to get a report from the Fodorpur police station. In fact, petition filed the FIR before all Omen police station at Palm Bazaar. Later on, they came to know that the case was transferred to Fodorpur police station. That is a region-wide report called from officer in charge. It has paid for some time to file a report. Heard Mr. President. I also called for a report from the All Women Police Station. For a copy of this order be given to. Yes, Mr. Sharma, why is that fire otherwise?
My lord, FIR is a
Page 10.
Yes. The fact remains that the
Sunitpur accused
Guwahati.
Hatigaon.
Hatigaon Road, Guwahati.
Cordial observation, we are individuals when we got a job there, I was living. Silsar, Badarpur. Posting.
Yes.
Accused was posted there in Badarpur.
Yes.
Last year. It was of 2019.
FIR is of 2019. Interesting.
Thereafter, last year in the month of November, I allowed his parents. Huh? What?
So relevant section here
After
490.
1 year, it was, oh, just. What is the sum and substance? The English is not,
My lord,
not very satisfactory.
allegation,
What is the sum and substance?
the allegation of the victim come informant was that they were in a relation.
With the accused.
Yes. And remained as a cohabited.
Live-in.
Yes, living. Thereafter, fixed for marriage from both the parties also. The necessary things were also arranged by the both parties. At the last moment, the accused, my lord, withdrawn
Stepped
from
away.
it. Yes,
Yes.
sent back. Thereafter, my lord, the mother of the accused called the informant, she is from Tezpur, at his house that we will talk together and give some solution. Accordingly, she came to Guwahati, remained there for 3-4 days. During that period, the accused constantly pressured her that I will not marry you, even physically assaulted her and tried to move.
So your FIR was registered.
Registered.
163 stroke,
Yes.
stroke 2019.
Yes.
All women police station.
Yes. And he was arrested, and thereafter, after 20 or 30 days, he was released on bail by the Honorable Court, High Court.
Okay.
Thereafter,
Then what is your grievance now?
first grievance is that after that, she visited the police station, all women police station twice or thrice, and they said that you will be notified from the court, Magistrate Court, Guwahati, for witness or something else. Nothing was done. Therefore, she approached me as an advocate personally recently. I went to the court and applied for the certified copies. There is not a single page regarding that case, all women police station case. Thereafter, I charged the register. The related, I personally checked there, the related cases are there, number is there, accused name, complainant name, sex, nothing was there. Now, if we, therefore, I filed this case. And interestingly, on the first occasion, my lord may peruse the order dated 27/5/25. First day, first order. 27th of May, 2025. This is the first order. After exactly the initial date, this was to be confirmed whether it was transferred or not, what is the status. That is why, as per that order, status report was called from the All Women Police Station. But till date, no report has been submitted by the All Women Police Station. I don't know why. But on my lord, that was listed thereafter, my lord, 5th of June, 12th of June, 19th of June. No report has been submitted by the OC, All Women Police Station. Thereafter, my lord, the matter was listed before your lordship, 27th June. That order may be looked into. 27th June.
Goswami.
It is not that no report has been, no communication has been made.
Badarpur
Yes.
station says no report.
Yes, my lord, a report has come from the Badarpur, my lord. It stated that from all women, it was transferred to Badarpur.
Right.
But in the Badarpur station also, when it has been searched,
No record.
nothing was found. It has been confirmed by the Badarpur, from the Badarpur PS also, my lord. Thereafter, that is why, my lord, again we have sent a
But it is too long now.
Yes, for that.
The time
on
that is taken by the officer in charge, All Women Police Station.
Yes.
Is too long now.
No, madam. Yes, all women, After that, my lord, since all omen, my lord, it was been transferred as it's been released, my lord.
There
So,
are 5 dates.
We have called for a report from Badorpur also, my lord. From Badorpur, it has been
Badorpur says no record.
Is a no record, my lord.
All Omen police station, no report.
Yes, no report. So, my
So
lord,
let the lady come.
now, my lord, so as per Badorpur's report, my lord, said that
Because if we see the bail order, let us see the bail order.
Page 20. Annex 3.
page
20.
All Omen police station case number 163/2019. The accused also got bail.
Yes, ma'am.
Right. And to cooperate with the investigation. Right. Further custodial entry is BA. It is not also anticipatory bail. BA means he was arrested.
Arrested.
In connection with police case.
Yes, ma'am.
So it cannot vanish
cannot be,
in
my lord.
thin air.
Yes, madam.
This is not a zero.
Yes, record.
On this, zero. And the PS case number is also there, madam.
So let us
But
see,
here,
let
my
us
lord,
count how many dates the
page-
officer in charge has taken.
My initial date of 20.
1,
Yes.
1, 2, 3. It is recorded on 19/6 that this is the third occasion.
Yes.
Yes, ma'am.
Goswami
Yes, my lord.
submitted a
just-
short date. Right.
Yes.
Then
On-
fourth date, 27/6. Then 16/7. So fifth occasion.
On 19/7, again, we have communicated, my lord. I just praying for just one date for tomorrow, my lord. But tomorrow, yes,
Okay,
tomorrow.
this is the last opportunity.
Yes, my
Otherwise,
lord. What has happened?
personal appearance will be called for.
Yes, yes, my lord.
Okay.
All men.
Yes.
I'm obliged.
As a last opportunity.
I'm obliged, ma'am.
Okay, Monday.
Monday, ma'am.
Heard Mr. D.K. Nath, learned counsel for the petitioner. Mr. M.P. Goswami, learned additional public prosecutor for the respondent state of Assam. So the petitioner has approached this court for after having failed to know the status of investigation of all Omen police station case number 163/2019, which was registered on the basis of an FIR lodged by the petitioner as the informant on 14/11/2019. So stop. The accused person named in the FIR was arrested in connection with All Omen police station case number so and so, and subsequently, he was allowed to go on bail by an order dated 6/12/2019, passed in bail application number 3745/2019 by this court, on the ground that his further custodial detention was not warranted for carrying out further investigation of the case. Post of para. When the petition was first moved on 27/5/2025, a status report as regards All Omen police station case number 163/2019 was called for. Post of. Thereafter, the case was listed on a number of occasions on so and so, so and so, so and so. This was the fifth or sixth occasion, fifth occasion,
Lordship.
when the officer in charge, all Omen Police Station, has failed to submit a status report as regards all Omen Police Station case number so and so. Post of para. Mr. Goswami, learned additional public prosecutor appearing for the state, has submitted, he be granted one last opportunity till Monday to obtain a status report from the officer in charge all Omen Police Station. Post of. The opportunity sought for is allowed as the last opportunity, with the observation that in the event of failure on the part of the officer in charge all Omen Police Station to submit a status report, the court, this court, may call for personal appearance of the officer in charge all Omen Police Station. Place the case on Monday.
I'm obliged.
Item 13.
May I please allow. Under if 528 application, my lord. Here, my civil liability has been converted to a criminal case, my lord.
Yes, Mr. Goswami,
Yes, sir.
where is the complaint?
Page 20 is the FIR, my lord.
2010 FIR.
Yes, my lord.
And why you are waiting so long?
In fact, my lord, charge has been framed only on, my lord, 9/5/24, my lord.
9/5/24,
my lord.
Page 36, man.
Page 20 is the, my lord.
Borrowed. If it is borrowed.
Yes, my lord.
How can it be 406?
Yes, man. No entrustment, man.
No.
At best, it could have been rightly or wrongly 420.
420.
Yes, man.
No.
Initially registered for 420 and 406 both.
Both, my lord. That is also not permissible, my lord.
Then my search sheet also, my lord.
Prima facie, the CGM had gone wrong
Yes, man.
in framing the charge. Anyway, borrowed money, hired Mr. J.C. Bora, learned counsel for the petitioner, and Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 1, State of Assam. This female petition under section 528B and SS is preferred seeking quashing and setting aside of the criminal proceedings pertaining to PRC case number 1154/2022, presently pending before the Court of Learned Chief Judicial Magistrate, Nagaon, and an order taking cognizance dated 9/5/2024. Full stop.
This is framing charge, man.
Hmm?
This is order
Framing charge. Dated so and so. Full stop. Para. The genesis of PRC case number so and so is an FIR lodged by the respondent number 2 as the informant before the officer in charge, Nagaon Hodor Police Station, against the petitioner as the sole accused on 7/9/2020. Post of a copy of the said affair has been annexed as Annexure 1 to this criminal petition. Post of. In the affair, it was inter alia alleged by the informant, that's respondent number 2, that the petitioner, the accused, had borrowed a sum of rupees 2,75,000 on 18/11/2008 for the purpose of doing business, and there was an agreement to return the amount within 1 year. Post of. as alleging that even even after elapse of 1 year and 10 months, the accused failed to repay the borrowed amount and had resorted to criminal intimidation, full stop. After investigation, a charge sheet was submitted finding sufficient material, finding a primacy case against the accused, that is the petitioner, for the offences under section 406 and section 420 IPC. Full stop. It was thereafter, the order dated 9/5/2024 has been was passed framing the charge under section 406 IPC. Full stop. The criminal petition is okay. Issue notice. The matter would require examination. Issue notice. Returnable on so and so. The petitioner shall take steps for service of notice as Mr. Goswami Likhibo. Mr. Respond number 2 Likhibo. Having regard to the contents of the FIR dated so and so, it privacy appears that the case allegations are of civil liability. Full stop. It is a settled position of law that a mere civil liability cannot be converted into, cannot be given criminal color. Full stop. It is accordingly, it is ordered, in the interim that the further proceedings of so and so presently pending before the court of so and so shall remain stayed till the returnable date.
Item 14. Mr. Lordship, the petitioners here filed this petition for quashing of the charge sheet and the subsequent PRC case is pending at the Court of Additional CGM Dibrugarh. The petitioners they are the investigators of insurance company. They were asked to do an investigation. They did the investigation, they submitted a report, and on basis of that report, the respondent number 2, she was a claimant, her insurance claim was rejected. Subsequently, she filed an FIR against us that we have cheated her. The FIR is on page 20.
This surreptitious manner, this is a document which you are relying upon to quash the proceeding, that 50%, 50 rupees higher charge.
Yes, Lordship.
We are not entering this. You face the trial. Because it is the materials which are collected during the course of investigation are to be taken note of, not outside material. And it is not a material of unimpeachable quality.
Lordship,
law is settled.
Maybe. Lordship,
I'll not say much.
Lordship, I have annexed this bail order. During the findings in the bail order is that
it is not. It is a tentative order. Bail or observations made. Show me the law. Bail or observations made.
No, sir. I'm not.
Is to be counted.
I'm not insisting on that. I'm not insisting on that. I'm just for the purpose of.
I will not say much. I have said this 50 rupees business.
Yes, Lordship. But the thing is, the Lordship, factual part is not because not of the 50 rupees. This is not part of.
I am not opening my mouth.
Yes.
Outside material is not to be taken into account for quashing an email proceeding when matter is solicited. Charge-sheet.
Matter is charge-sheeted.
Charge
Show
also-
me.
Cognizance has been taken on
When
420.
outside material can be taken. These are outside material.
These are outside material.
These statements prepared by you. What is the law? Is it unimpeachable, sterling quality?
For the purpose of success.
Sterling quality or not? You have prepared the statements.
Yes, I have prepared the statement. She has given the statement, Lordship. We have
What evidentiary value you adduce it is as defense evidence? This 50 rupees. Have you seen it? Have you seen it?
Indicated by loss.
You see.
Yes.
But the allegation is that.
You see.
No.
To defeat a claim of insurance,
No.
people can go to this
But the
extent.
thing is, Lordship.
Unknown passenger,
50 rupees.
50 rupees rent fare.
Rent.
Mr. Roman
But she has herself given.
will come hers.
She has herself given a statement. She can challenge that reputation claim.
It is not a Rukmini kiba asil.
Or she could have.
Devendranath Padhi eta ase neki Devendranath.
But she could have challenged that. Or
Art. Mr. S.M. Roman. I am dismissing. This kind of practice will not be allowed before this court. It is not a document of unimpeachable character and sterling quality. This is a document prepared by you by calling the insured, right? Prepared,
Again,
incorporated 50 rupees
50 rupees.
to defeat a genuine claim.
But she could have, to the best of her knowledge, she have not challenged that or that reputation before any court. This is the best of our information of it.
Mr. MP Usman. Learned additional public prosecutor for the respondent state. Full stop. The instant criminal petition and the section 528 BNSS is preferred seeking setting aside and passing of a charge sheet submitted on 25/2023 in connection with Dibrugarh Police Station case number 1917 stroke 2000.
2022.
Okay. 2021. Registered on her life, full stop. In the FIR lodged on
2/10/21.
2/10/2021 by the respondent number 2 as the informant. It was inter alia alleged that she was the insured of a four-wheeler vehicle, bearing registration number AS-22/G-6973. Within bracket Maruti Suzuki Dzire VXY page 20. Within bracket the subject vehicle for short. She was the owner. And the vehicle and the subject vehicle was insured under a policy from Messrs. Universal Sompo General Insurance Company Limited. for the period from 2012 to 2021 to 11 to 2022. Full stop. The subject vehicle met with an accident on 8/7/2021. And a claim was registered against the insurance policy taken for the subject vehicle with Messrs. Universal, with the insurer, comma, Messrs. Universal Sompo General Insurance Company Limited. Full stop. Para. The two petitioners hearing are official stroke insurance investigators from Messrs. So and so. Full stop. Para. In the FIR, comma, the informant had further alleged that the two petitioners, in order to investigate the claim made in respect of insurance claim made in respect of the subject vehicle, comma, fraudulently recorded the statement of the informant and her husband exercising deceit. Full stop. Para. The affair. Sorry, the investigation of so-and-so case number was carried out, and upon conclusion of investigation, comma, the IO laid a charge sheet bearing charge sheet number 195 on 31/5/2022, finding sufficient materials against the two accused, namely, comma, Hoyogrev Bishwas and Titho Bol, page 41. That is the two petitioners hearing for committing the offenses under section 420 and section 406 of the Indian Penal Code. Full stop. Para. In this criminal petition, comma, the two petitioners have annexed documents which are stated to be part of their investigation carried out against the claim for insurance made by the insurer informant pertaining to the subject vehicle. Full stop. Statements, two statements of the insurer informant and her husband have been are annexed as part of the case papers. Full stop. The petitioners have projected that on the basis of the records collected, on the basis of the informations collected during the course of their insurance investigation against the claim, more particularly, comma, the two statements recorded of the insurer informant and her husband recorded, comma, it had emerged that when the subject vehicle had proceeded, insured, that's informant, proceeded from the house of the insured informant on 8/7/2021. It took an unknown passenger in it by taking a ramp fare of rupees 50,000 through the driver. Full stop. It was on the basis of such finding, the insurance claim was rejected on the ground that the subject vehicle was involved in hire and reward. Full stop. Para. Rukmini Navlekar. Rukmini. Para the reliance has been placed on those on the documents collected during the course of investigation carried out by the petitioners as insurance investigators for setting aside and quashing of the charge sheet dated so-and-so and the proceedings of PRC case number so-and-so. The law is to settle that to settle the law is settled by the Honorable Supreme Court in Withdrawal versus so-and-so, 1993 supplementary so-and-so. To the effect that it is the allegations made in the FIR which are to be looked into to find out whether the ingredients of the offense alleged are made out or not. Full stop. When a charge sheet is challenged, so when charge sheet is sought to be quashed, that is the materials collected during the course of investigation are to be looked into. Full stop. For quashing of a criminal proceedings, including a charge sheet and stroke FIR, ordinarily, defense materials cannot be looked into by the court. Full stop. Only in very rare and exceptional cases where the defense material convincingly demonstrates that the prosecution version is totally absurd or preposterous, and in such very rare cases, the defense material can be looked into by the court and full stop. It is also not an absolute proposition that under no circumstances can the court look into the material produced by the defense at the stage of considering an application, a petition under section 420 C, B and S. Full stop. If such material produced by the defense convincingly establishes that the whole prosecution version is totally absurd, preposterous or concocted, then and of unimpeachable and sterling character, the same can be looked into. Full stop. In the above backdrop, when the defense materials, when the materials sought, where the petitioners have placed reliance for setting aside and quashing of the proceedings of PRC case number so-and-so and the charge sheet dated so-and-so, this court is of the unhesitant view that the materials produced by the petitioners do not fall in the above category, mentioned above. Full stop. In view of the above discussion and for the reasons assigned, this court does not find any prima facie case to enter in this writ petition. Full stop. The petitioners who have been solicited have all the opportunity under the law to disprove the allegations brought against them. Full stop. Accordingly, during the course of the trial, according this petition is dismissed.
Item 15.
No point.
No.
Yes.
No, it's.
My lord,
Yes.
this case, my lord, I want to withdraw this case, my lord, with liberty to file it thrice, my lord. In prayer person, I have to make.
376 compromise.
My lord, I was seeking, my lord, because my lord, incident.
376 compromise. Okay. Okay, liberty. Eke Azad. Learned counsel for the petitioner. Has submitted that the petitioner wants to withdraw the instant criminal petition with liberty to file FS. Mr. MP Goswami, learned additional public prosecutor who is in attendance, has submitted that the state has no objection to the said prayer. In view of the above submission made by Mr. Ajay, learned counsel for the petition, the criminal petition is dismissed on withdrawal with the liberty as prayed for.
16.
Yes, default.
Default. Yes, my lord.
How much?
My
Where is the FIR?
FIR is page, my lord. A party part is my
30,
page
right.
15, my lord.
15. Then
Then my
what happened?
I was arrested, my lord.
Arrested.
I was allowed to go on bail, my lord.
When?
I was allowed to go on bail, my lord. My lord.
17.
Said 27/1/2021, my lord.
Page 17.
Page 17, my lord.
Thereafter,
Thereafter, my lord, SARS was fame, my lord.
when charge sheet?
SARS 20 to
Let us see charge sheet.
2021.
Charge sheet. Not enclosed.
Not enclosed, my
Okay,
lord.
where is the first order before the court?
First order, my lord.
For considering you initially appeared.
Yes, my lord.
Okay, this is a trial court, page 17.
Yes, my lord.
Page 17 is a trial court. Or 437.
Trial court, my lord.
PR case, now I think trial court.
Page 36.
Page 17, man.
Trial court perhaps. Then you were absent with steps.
Yes, my lord.
When? Up to when?
Up to my lord, 16/6/2022.
Page?
My lord. Page, my lord, 16/6/2022. Sixteen to 16/6/2022, my lord, page 34, my lord.
Page 34.
Yes, my lord. no report is received on NBW issued against him. Issue freeze NBW.
Page, not third, page 34.
34, my lord.
Huh? What is 31 then? NBWA,
Yes, my lord.
that was the first date.
Yes, my lord.
Then why you are referring to 34?
He has not appeared since then.
Since my lord 16/6/2020.
16/6/2020 or when it was?
22, my lord.
Huh?
Page 34, 22.
What is 31? Page
16/6/2022.
31.
31 is case record is put up today before me, honorable. My lord, there's a, this time one notification one issued, my lord, from Guwahati High Court during Corona COVID time, my lord.
Let us see subsequent order.
From page 33. Also. Page 32 also.
No, not COVID time. Every time NBW was issued.
On page 32.
Page 31, I limit it to issue NBWA.
Yes.
It started from that point.
That point.
I think I am more aware than you.
Yes, my lord. Thereafter, he was arrested, my lord.
When arrested?
Page 35, my lord. Annexer H. 7.
Arrested?
Yes, my lord. 17/7/2022. The accused person, Dulab Khonikor alias Krishnaraj, produced on arrest in his rank of NBWA, my lord.
So you have not mend your ways?
No, my lord. Arrested, again bail, again arrested.
My lord, there is a reason, my lord.
What reason?
My lord, he is a unsound, my lord, my lord.
Unsound?
Yes, my lord. There is a prescription, my lord.
Where is that?
Medical prescription is phase, my lord.
Mr. Goswami, when it started again NBWA?
Again, my lord, page 36, my lord. Second time he is allowed to go on bail, man.
Someone issued.
Yes.
Sure. Remand the accused. 30,000.
No, 30.
Yes, man.
Okay. Then he went on bail.
Yes, man. Again, my lord, from 37 he was again absent.
Okay, absent, okay. NBWA.
NBWA, man.
When?
Up to, my lord, 4/7/2025, my lord. Page 64, my
Who
lord.
is absent? Peruse the record. Issue and I think page 38.
38, 25/11/22, my lord.
This is the date.
Again,
This
my
is
lord.
again, my lord, NBWA was issued, my lord.
So where is your mental illness?
My lord, page, my lord, 67, my lord. Left side, my lord, 6 month duration.
Since when?
5/24, my lord. Date was 5/9/2024.
Heart. Yes.
Right.
We'll keep it in advance. Yes. Heart, Mr.
N. Borua.
N. Borua. Learned counsel for the petitioner, Mr. MP Goswami Learned, additional public prosecutor for the respondent state, first of the instant criminal petition under section 428 BNSS is preferred, seeking setting aside and passing off an order dated 25/11/2022 and all subsequent orders whereby the Court of Learned Chief Judicial Magistrate Soraideo at Sonari has issued non-bailable warrants of arrest against the petitioner to secure his appearance before the said court in PRC case number 19/2021. Full stop. The genesis of PRC case number so and so was a first information report lodged by the informant Rinku Bora before the on 7/11/2020, alleging cheating against the petitioner, alleging cheating and criminal intimidation. Full stop. The said FIR was registered as Kakotibari,
Yes, my lord.
Kakotibari Police Station. Case number 40/2020 under section 420 and section 406 from IPC. Full stop. In the course of investigation, the investigation resulted in a charge sheet. Full stop. Upon charge sheet, upon submission of the charge sheet, PRC case number so and so was registered. Full stop. The accused, the petitioner, was taken into custody. Full stop. On 27/1/2021, the date fixed for consideration of charge, the accused was allowed to go on bail of rupees 20,000 with 1 COT pursuant to an order dated 11/1/2021. Post of thereafter, the accused, either by appearing in person or by taking steps, was participating in the trial in the proceedings of PRC case number so and so. However, on 25/11/2022, the accused, the petitioner was absent without taking any steps in the proceedings of PRC case number so and so. Post of in view of such absent without steps, the trial court ordered to issue non-bailable warrant of arrest for securing the appearance of the petitioner in the proceedings of so and so. Post of the subsequent orders in view of non-appearance of the petitioner before the learned trial court, the subsequent orders were passed issuing non-bailable warrants of arrest against the petitioner. Post of on the last date of posting of the case, that is on 4/7/2025, the learned trial court again ordered for issuance of fresh NBW against the petition. It is in the above backdrop, the petitioner has preferred an instant criminal petition. One of our grounds asked regarding non-appearance of the petitioner is that the petitioner is a person suffering from psychiatric problems. In support of such contention, the petitioner has annexed documents annexed from page number 65 to 76. Post of para. The FIR was registered as far back as on 7/1/2007,
2020.
11/2020. Post of. It cannot be denied that an expeditious and fair trial is in the interest of all the stakeholders, including the prosecution, complainant stroke, informant stroke victim, the witnesses, as well as the accused. Full stop. Mr. Burwal and counsel for the petitioner has submitted the petitioner is ready and willing to participate in the trial by submitting himself to the jurisdiction of the line trial court within a period of 2 weeks from today. Post op. It is with the apprehension that the warrants of arrest issued against the petitioner would be executed before submitting to the jurisdiction of land trial court, the petitioner has approached this court seeking relief. Full stop. Having regard to the considering an expeditious conclusion of the trial of PRC case number so and so, and accepting the undertaking given by the petitioner that he will be appearing before in the proceedings of so and so, henceforth without any default. This court is of the considered view that in order to, in the interest of justice, command warrants of arrest, non-NBWs issued against the petitioner by the order it is so and so, and all subsequent orders can be kept in abeyance for a period of 2 weeks from today, so that the petitioner can appear and submit to the jurisdictional line trial court to participate in the proceedings of PRC case number so and so, further proceedings of so and so. Accordingly, it is ordered that the petition shall appear before the court of so and so within a period of 2 weeks from today, and during the same period, the NBWs issued by the order dated so and so, and all subsequent orders shall be kept in abeyance. Full stop. It is further observed that if the petitioner upon his appearance submission the application for bail, Commander Land Trial Court shall consider the same on its own merits and in accordance with law. With the above observation and the criminal petition is disposed of.
Item 17.
Please, Lordship. Here in this case, Lordship, this 528 application has been filed for quashing the charge sheet. The issue is that, Lordship, the petitioner has been implicated in that particular FIR, and there is an allegation of impersonation on his part. Now, what has happened, Lordship, just
No, what do you want?
Lordship, quashing of the charge sheet, Lordship. There is no mentioning on my part, Lordship. Since 2017, I filing.
Very good.
Since 2017, Lordship, I've just annexed all the relevant documents, Lordship. Since 2017, I'm filing my Hajira in the name of Jamiruddin, Lordship. What has happened? This 2013 FIR, Lordship, the police apprehended me as Amiruddin Mojumdar. Then I filed a bail application before this honorable court, and I don't know what has happened, but by not expressing that aspect of the matter, wrong identification, the bail application.
Unbelievable.
Lordship, if your Lordship kindly see my Hajira.
Unbelievable.
Lordship, kindly see my Hajira. In every Hajira, I have mentioned my name as.
Manipulation all throughout since 2017.
No, Lordship, nothing like that. Lordship, kindly see my Hajira. In every Hajira, I mentioned my name as Jamiruddin Mujumdar.
Cannot be.
Lordship, I have annexed all.
No prudent person can accept your
proposition. Lordship, I have annexed my Hajira.
I have seen.
In that Hajira.
I have seen.
Yes, Lordship.
This is impersonation of the highest order.
No, Lordship, in the bail application also, if your Lordship kindly see, I'm just referring to page number 40.
Let us see the bail application.
Yes, Lordship, 41 and 42. This is the
You
order.
have the audacity of seeking passing of this petition.
Lordship, kindly see, 40,
Right.
42, Lordship.
An FIR lodged by the court, right?
Yes.
You have the audacity.
Lordship,
Let us
kindly-
see
Yes, yes, Lordship.
Let us examine your test, your audacity.
Yes,
Let us see the come page to
Page number
41.
42.
Come to page 41.
Yes, Lordship. Starting
What did you say? You are Amiruddin Majumdar.
I am Jamiruddin Mojumdar.
No, in the petition,
In
cross
the
title.
petition. Exactly, that is what I'm saying.
That is what I am saying also.
Yes, Lordship. But
What did you represent before this court, High Court?
as Jamiruddin Lordship.
No, Amiruddin.
No, that was at the time of filing the bail application. Yes. That
Why
was
should-
done. I'm not.
Why should we not take cognizance of these facts? You were arrested in connection with Silsar police station.
Exactly,
case
Lordship.
now. There were two other accused, right?
Yes.
Now you projected yourself as Amiruddin Majumdar before this court.
I was arrested at that point of time.
Huh. So you did not say that.
Yes, Lordship.
What did you say?
Yes.
Place the bail application before this court, copy of this, get a certified copy.
I can understand,
At
Lordship.
that point
was
of
done-
time, you are Jamiruddin. Still you are projecting as Amiruddin. Am I right or wrong?
No, that point of time.
Am I right or wrong?
Yes, Lordship.
This can be answered in yes or no.
Yes. Presently, I'm
Yes.
Jamiruddin.
Yes.
Yes.
Now, after 7 years, you changed to Jamiruddin.
No, 2017. I've been filing my Hajira.
8 years. I'm
Yes.
sorry.
2017.
I'm sorry. Not 7, 8. You projected yourself Amiruddin. Now, when the FIR was lost, everything is almost, there is no light at the end of the tunnel. You have started becoming Jamiruddin. So you are Jamiruddin also. Then why you are accepting your position as Amiruddin? This is egregious.
No, Lordship. The difficulty is that, Lordship, I was behind-
Brandisman is too
No,
high.
I was behind the bar during the relevant period of time. The bail application was moved. The instruction was there, but the how the bail application
How
was
rich
moved,
are you? Tell
that-
me.
That was not under my control, Lordship.
Control?
Exactly.
What
Lordship.
is this?
And thereafter, if your Lordship kindly
When did
see,
you say?
Lordship kindly see the Hajira. I've given all the
Read
Hajira.
your affair.
Lordship can annex just
Let us refresh page 26.
Page 26. With reference to the subject cited above, I have the honor to state that from perusal of the relevant orders and other materials available in the aforesaid case record, it appears that the IO submitted charge sheet against 3 persons, namely Altaf Hussain, Morbhuya, Safiquddin Lashkar,
And Amiruddin Majumdar,
Yes.
son of
Harun
Harun Rashid.
Rashid.
It is clear?
Exactly, Lordship.
Right.
Yes.
This was a case of which year?
2013, Lordship.
2013.
Yes.
Let us read further.
In the course of trial, the accused person.
No, the address of.
Address. FIR.
The FIR in connection with this case was lodged by.
No,
Yes.
page 26.
I'm just reading page 26 now.
After Amiruddin Lashkar, son of Harun Rashid.
Harun Rashid. The address of the Amiruddin Majumdar is given as Sonabari Ghat Part 2 PS Silchar.
In that affair.
Yes.
In that affair.
In that affair, Lordship. The FIR in connection with this case was lodged by Army personnel on 2/9/2013 against the said 3 persons. In the course of trial, the accused persons Altaf Hussain, Borhuya, Safiquddin Lashkar appeared and they are facing trial. Accused Amiruddin Majumdar also appeared after obtaining bail from the Honorable Guwahati High Court. As it appears from the order
But
dated.
this line, please. This is interesting.
Yes, Lordship.
This is interesting.
12/10/2013.
Accused Amiruddin Majumdar
Obtained bail order.
also appeared. He did not initially appear.
After obtaining.
Altaf Hussain Borhuya and Safiquddin Lashkar, they appeared and they were facing trial. Accused Amiruddin Majumdar also appeared after obtaining bail from the Honorable Guwahati High Court. As it appears from the order.
He was in custody, Lordship, during that period. He was in custody during that period. After obtaining bail order.
So,
yes, Lordship.
He appeared as Amiruddin Majumdar. Right?
Yes.
So, Amiruddin Majumdar. And behind that is Jamiruddin Majumdar.
Yes, Lordship. He was actually Jamiruddin, but
And what
the
did
bail
he say?
application was presented.
During last 8 years?
Yes. Now.
Tactfully filing the Hajira in the name of Jamiruddin, a Hajira, Mr. Poddar and Mr. Darakulla. Do you see the Hajiras who files? Mr. Chaudhary, it is too much dangerous game you are playing. Hajiras now you are annexing.
No, just.
And all the while you are Amiruddin before the court. And Hajiras now you are annexing that in the Hajira, I have mentioned my name as Jamiruddin, not Amiruddin. Am I
Yes,
clear?
pausing for a moment,
Is
Lordship.
it correct?
Yes, yes.
Is it correct?
Yes, Lordship.
Then who looks at the Hajira?
No, I'm
Bench assistant.
exactly, Lordship.
Right. Neither the session judge,
No, why I'm referring to
neither the PP.
exactly, Lordship.
Right. And all along, you are Amiruddin.
Prior to the
You
time.
did not say before the session judge, nor to the PP, right? You surreptitiously filing Hajira in the name of Jamiruddin and impersonating as Amiruddin. End of the game.
No, Lordship, why I'm referring to
No more permissions.
because in the bail order also, Lordship, it has been reflected that the Amiruddin is.
Why you have come, if you are really a Jamiruddin,
Yes, Lordship.
why you have defrauded this High Court, projecting yourself as Amiruddin? Are you one of the counsels, Mr. Chaudhary?
No, no.
During the, he has been changing advocates. I think advocates goes out. You have changed 5-6 advocates.
Not 5-6, Lordship.
5-6. I have, how many?
Not 5-6.
How many? Are you one of the counsels?
No, I was not there.
Huh?
I was not there at that point.
Because there was a game going on.
It's not like that, Lordship, because he was he tried to pursue.
This is too much.
Lordship, I can understand the
For a
difficulty.
person sticking Quashing.
Exactly, Lord. Difficulty is there, Lordship, but there is no other option on the part of the petitioner also, Lordship.
Face the trial.
Because other
Face
way,
the trial.
even in the
Show your bona fide.
exactly, Lordship, even in the bail order also, it has been
Every presiding officer may be a witness also of the court.
exactly.
That I have seen him. He was facing the trial. See the gravity of the offense.
Other way, Lordship.
You have taken the entire judicial machinery for a ride. And then the Amiruddin will come later on, resurface. It is a mistrial.
That
It is too much.
I'm just
I'll keep this with patience. I'll pass the order with some cost.
a poor man.
Today
Lordship.
other matters are there.
Poor man,
Maybe
Lordship.
tomorrow.
Without any bona fide intention, he has filed this quashing
Very
petition,
good.
Lordship. Because
We'll
there is a bona fide reason for
we'll
filing
try
that.
to find out
Lordship may
absence of
appreciate,
mala
Lordship may not appreciate, but the thing
We'll try to find out absence of mala fide.
yes, Lordship. Yes, sir, to your Lordship.
Mr. Sharma,
My lord,
you point out each and every detail.
my
How
lord,
many times he has
yeah, my lord, in
changed
the
how many
pay,
Hajiras?
yes,
Since 8 years, High Court,
yes,
everybody was taken for a ride.
yes. And in the, my
After
lord,
8 years, he
Yes.
says, I am Jamiruddin.
yes, in 78, my lord, there is.
No,
Note down
Yes.
so that I can dictate
not
the
after
order
8
in
years, Lordship.
detail.
I'm just referring to one, just, if your Lordship kindly permit me. I'm just referring.
After dictating you whatever citations you want to show, you show. Whatever. Whatever judgments, ratio laid down by Honorable Supreme Court, even Privy Council, House of Lords, everything. Right? This is taking for a ride. How many manpower, man days are lost for you?
And that has started only because of my wrong detention by the police, Lordship. Because I
Oh,
was
too much. Okay, we wait. SP Chaudhary, P. Sharma, some other date. Taking time, I'll pass this order. Monday or Tuesday. Tuesday.
Wednesday, Lordship. Monday, Tuesday, I'll not be there, Lordship.
Okay, Wednesday.
Wednesday. Always.
6 August.
For further hearing.
Item 18.
Yes, Mr.
My lord, 302 petition was filed, my lord. That was rejected, my lord.
Ipse Dixit.
My lord, actually, what happened was there was no,
Ipse Dixit.
my lord.
You take resort to 301, not 302.
Or Lordship may permit. to
No
file a
permit.
Fresh petition stating reasons.
Not permitting. Come to page 10.
My lord.
You resort to 301. CRPS.
My lord.
I am granting liberty.
Yes, my lord. My lord, in this petition, what happened? My lord, there was no reason. That is,
You cannot demean public prosecutor.
nothing was mentioned here, my lord.
Nothing was mentioned.
That is the reason.
So that is why I said ipse dixit.
My lord.
Do you understand the meaning of ipse dixit?
No, my lord. Sorry.
At the mere wish,
It is.
you cannot conduct prosecution. And still you are pursuing,
The revision was preferred.
not satisfied. Private vendetta or what?
498A, my lord, the allegation is of my lord 498A, my lord, and dowry provision, my lord.
Yes, Mr. Sharma,
My lord.
you want to be replaced.
My lord. I hope.
You are supposed to be replaced.
Yes, yeah, I am supposed to be replaced
Yes.
by someone.
Yes.
Yes.
What to do?
My lord, that cannot be, my lord.
What is there? Otherwise, the reason was not mentioned, my lord.
Good enough. That is why I said ipse dixit.
It's serious.
So dismissing it.
My lordship may grant me.
Two courts have found
My lord.
ipse dixit. This court is also affirming that. But
My lordship may grant me liberty to make fresh application with all the
What?
reasons before the.
no fresh application. You can only you assist the public prosecutor by engaging a private lawyer under 301, not 302.
301.
My lord.
This one is gone.
My lord.
So I can observe that if a petitioner files any application under section 301
Right.
CRPC, what is the relevant provision now? BNSS?
Yes.
You have exhausted the remedy trial before the trial court, before the divisional court. You are still seeking invocation of inherent power without any reason.
Yes, ma'am. No reason was there. In my lord. I have seen.
See the equivalent provision of
Yes, yes.
338, my lord.
330.
Heard Mr. R.S. Mitchell and counsel and person petitioner and Mr. B. Sharma and additional public prosecutor for the respondent state. Because after hearing the learned counsel for the parties on the impugn order dated 2/4/2024, passed in PRC case number 41/2023 and 18/6/2025, passed in criminal revision number 3/2024 by the learned session Judge Dhemaji, which orders were passed on the application filed by the petitioner before the learned trial court under section 302 CRPC, a copy of which is annexed as Annexure A to this petition, Mr. Mishra, learned counsel for the petitioner, has submitted that the petitioner would not pursue the matter under section 302 CRPC and would like to seek leave under the provisions of section 301 CRPC, which is under the section 328.
No, 338. 338.
338 B and SS, which is perimeter to section 301 CRPC. Full stop. In view of the, it is noticed that both the learned trial court and the revisional court has observed that the the prosecution, one cannot be allowed to conduct the prosecution on the mere ipse dixit. Full stop. Without commenting further, without commenting further on the issue, this criminal petition is dismissed on withdrawal as prayed for by Mr. Learned Constable, the petitioner. Full stop. The petitioner is at liberty to seek to submit an application before the trial court under section so and so 430 BNSS, and the land trial courts upon such applications shall decide on its own merits in accordance with law.
Item 19. May I please tell Lordship, the petitioner is the accused in an NI case. And he
How much NBW?
NBW.
Since when?
14/9/23. Yeah.
What is the proceeding? That is the case number. That is page 23. Complaint case.
Page 23.
You are Vishnu Das.
Vishnu Das, you know, accused.
Vishnu Das.
Yes.
How much check? 5,06,000.
5,06,800. Yes.
Then you appeared initially.
Yes, I have appeared initially.
Since when you defaulted?
14/9/23.
Page?
Page 4.
Page?
Actually, you know.
No. Page?
No, petition. Default page. Annex 3. Page. One.
When? First started?
Page 48. Annex 5. You know.
The starting date?
14/9/23.
Okay. Art, Mr.
D. Majumdar.
D. Majumdar. Petitioner. B. Sharma. Public prosecutor, additional public prosecutor. The instant criminal petition under section 428 Bharatiya, under section Bharatiya Nagorik Surokkha Sonhita is preferred, seeking setting aside and quashing of an order dated 14/9/2023 and all subsequent orders dated cause title whereby the trial court of Judicial Magistrate First Class Kamrup Metro Guwahati has issued non-bailable warrants of arrest against the petitioner, who is the sole accused in the proceedings of NI complaint case, NI Act case number 1815/2018, pending before the State Learned Trial Court. Full stop. What is your ground? Full stop. In the complaint
I went
of
to the
NI case number so and so, the petitioner has been arraigned as the sole accused in view of dishonor of a check amounting to rupees 5,06,800 issued by him in favor of the complainant therein, on an account maintained by him at the State Bank of India. Dispur branch. Post stop. The complaint has been lodged for the offence under section 138 NI. Post stop. After cognizance, after taking of cognizance, a process was issued against the petitioner, and he after receipt of summons, appeared before the learned trial court. Post stop. On application being made, the petitioner was allowed to go on bail on 19/12/2018. Post stop. During a subsequent period, the petitioner continued to appear in the proceedings of NI case number so and so until 14/9/2023. Post stop. On 14/9/2023, the petitioner failed to appear before the learned trial court, and there was no steps taken on his behalf on that day. Post stop. The learned trial court, finding the petitioner absent, issued non-bailable warrant of arrest against the petitioner. Post stop. On the subsequent dates on so and so, the learned trial court issued warrants of arrest to secure the appearance of the petitioner in the proceedings of NI case number so and so. Post stop. In the above backdrop, the petitioner has approached this court by the instant criminal petition with the above prayer. Post stop. Mr. Learned additional public prosecutor has submitted that there is no illegality and arbitrariness in passing the orders dated so and so and others and other subsequent orders. Post stop. The Mr. So and so learned counsel for the petitioner has submitted that the petitioner is ready and willing to participate in the proceedings of so and so, henceforth without any default. Full stop. আগৰটো নিচিনা লিখি দিব আগৰটো ডিসপোজ কৰিছিল লিখি দিব 2 weeks or within 2 weeks. Any next date?
Next date 6/8/2025. Next date.
Okay. Next date then 6/8. 6/8. Okay, 6/8. You appear till then. Captain Evans.
Item 21.
Hello. এটা 11 নম্বৰটো আছিল 11 নম্বৰ কোনটো আছিল কোনবাৰ আছিল 16 ন 16 লিখি দিম Yes.
Here the petitioner was facing trial, Lordship, in Sessions case number 14 of the 2023, and he was regularly appearing, Lordship.
How
But
many
no
default?
prosecution witness.
Only one?
Yes.
Single default?
Yes.
One time?
Yes, yes.
Yes, mister. One time. When is the next date?
Yes, Lordship. Day after 2 months.
Okay.
Second of
Mr.
7 days.
J.J. Ramit, learned counsel for the petitioner, and Mr. B. Sharma, learned additional public prosecutor for a respondent state. Post of the petitioner has approached this court by the instant criminal petition under section 438, 528B and SSC to assail an order dated 10/6/2025, whereby the Learned Sessions Court, South Salman Mankasar, has issued non-bailable warrant of arrest against the petitioner. Post of. It is stated that in Sessions case number 49/2023, the petitioner is facing a trial for a charge under 376 IPC.
Subsection 1I.
Post op. It is stated that after the charge was framed on 27/2/2024, to which the petitioner pleaded not guilty, Trial proceeded to the stage of recording evidence. During the period subsequent to 27/4/2024, the petitioner was regularly present before the learned Sessions Court until 10/6/2025. What is the reason for your failure? Any?
Lordship, on that, the advocate with wrong diary entry, Lordship.
Okay. It is averred that on 26/3/2025, the petitioner was represented before the learned Sessions Court through his engaged learned counsel as no witness turned up on that day. The case was
Never
again
done.
posted.
Witness, Lordship, all the dates witnesses are not done.
No, we're making it short since the case is day after tomorrow. As no witness turned up on 26/3/2025, the case was again posted, was posted on 10/6/2025 next for evidence. It is further stated that due to wrong diary entry of the case by the learned engaged learned counsel of the petitioner, the engaged learned counsel could not take steps on behalf of the petitioner on 10/6/2025. The overlooking the fact of regular presence of the petitioner on all earlier dates, the session judge on 10/6/2025. Session judge 10/6/2025 had proceeded to issue non-bailable warrant of arrest to secure the appearance of the petitioner in the proceedings of Sessions case number 49/2023. Hey, 16 to লিখে দিব। The petitioner has under. When is the next date? 2/8.
2/8.
What will লিখে দিব? 6/8 অর্থাৎ 2/8 লিখে দিব। The last লিখিব the learned Sessions Court, while considering the prayer for bail, shall take into consideration the presence of the petitioner before it on dates earlier to 10/6/2020.
Item number 23.
Please, Your Lordship. So this is a criminal petition. Praying for passing of that proceeding, my lord. The proceeding is a, my lord.
You are what? How related you are?
I am
the
the
aggrieved person.
I am the sister-in-law of the aggrieved person. my lord.
Do you reside with her?
No, my lord.
No.
My lord, may kindly see their complaint, my lord.
No, do you reside with her?
No, I am not resided with her. And
Okay.
others,
Where is your statement? Where is your state?
my lord, paragraph 6.
Okay. Heard Mr. M. Dr. Learned Counsel for the petitioner. Post up. The petitioner has instituted the instant criminal petition under section 528 criminal party on Nagorik so and so, setting aside in passing of the proceedings of DV, Miss DV case number 61/2024. Presently pending before the Court of Learned Judicial Magistrate First Class Golaghat. Full stop. The proceedings of DB case number so and so, this DB case number, has been instituted on the basis of an application filed by the respondent hearing as the aggrieved person who has sought reliefs under Section 22 and Section 23 of the Protection of Women from Domestic Violence Act 2005. Full stop. The issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondent by registered post with AD. Full stop. It is categorically asserted on behalf of the petitioner and at paragraph 6 of the instant petition that the petitioner is a sister-in-law in relation.
So again,
Protest petition.
protest petition has been filed by the respondent, my lord.
Okay, accepted final report.
Yes, my lord.
Then complaint case.
Complaint case.
Registered.
Then protest petition has been registered as complaint case CR
Right.
55 2025.
Right. Registered as complaint case.
Yes, my lord.
Transfer the coincidence original case of also. Original case ready for trial disposal. So this is the when it happened. When it happens, 24/1/2025. So it will be proceeded as per BNSS?
No, my lord, because
Why?
now proceeding will be as per BNSS.
Then you will have what we have found in the other case. In the other case,
Yes, my lord.
BNSS,
Yes, my lord.
I have learned. How much I have learned, I don't know. What is the provision, Mr.
That means saving clause, my lord.
No. That Mr. R. Bora was. I have found this new provision. Initiation of. It was just R. Bora to guess. Who was there? Mr. Borua was there. Or? New procedure for initiation of complaint case.
Oh, my lord, 210, my lord.
210.
210. 110.
No. Cognizance. Oh.
Perhaps it is, my lord, 223.
223. Yes, my lord.
No cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard.
That has been done, my lord.
Done.
Yes, my lord. Your lordship. Hey. Yeah, that would be.
Why don't you annex those?
My lord, I have received it later, my lord. My lord. 223.
So opportunity was granted.
Yes, my lord. So we have submitted, my lord.
Oh, in between orders, you have not annexed.
Yes, my lord. That remain, my lord.
Don't do it. Where is the complaint?
Complaint
Yes,
at
Mr.
Page 35, my lord.
State is a party.
We are
No,
not
no.
comfortable.
No, state is not a party, my lord.
Heard Mr. D.P. Bora, land council for the petitioner. As post of the instant criminal petition under code 528 BNSS is prepared seeking setting aside of the proceedings of CR case number 55/2025 presently pending before the Court of Land Subdivisional Judicial Magistrate as number 1 Kamrup Metro Guwahati and an order dated 23/5/2025 passed by the Land Trial Court, Trial Court Depot. Upon a complaint lodged by the respondent's informant as a Narazi petition to a final report submitted by the investigating officer of Gorsuk Police Station case number 196/2013. Full stop. The complaint stroke complaint. A copy of the complaint has been annexed to the instant criminal petition as annexer
6.
Huh?
Annexer
6,
6, my lord.
6. Post of. The gist of the allegation made in the complaint GIST, GISTS, are interior to the fact that the respondent as informant's father. No, the family of the respondent as informants paid a sum of rupees 5 lakh in order to purchase a plot of land measuring
1 kotha, my lord.
1 kotha from the petition number 1 post of the petition number 2 is the wife of the petition number 1 post of in the it is alleged that in the year 2000 it was projected by the petitioners to the family of the complainant as informant that a plot of land was a periodic patalan?
No, my lord. In the sale deed itself, it has been mentioned. Only
Where is the sale deed?
Say annexer 1, my lord. I have annexed it. And they have also annexed it with their petition. Annexer.
Sir, why you are taking me to annexer 13? Nekibu Roman versus Yater Parvin Bora.
Yes, my lord.
Who is this lady is not Yater Parvin Bora.
Yes, my lord. That's why I am submitting. The mother of the complainant.
Pompi Bora's mother is
Yater Parvin Bora.
Is it?
Yes, my lord. That is the case, my lord. So this sale deed, my lord, was executed for selling the possessory right only because it was a government land, my lord.
Sum of 5,000 at a consideration amount of rupees 5 lakh. Post of Mr. Bora, Land Conservator petition has referred to Annexer 1 agreement entered into by the petition number 1 with the mother of the complainant respondent, whereby only possessory right with regard to the subject plot was sold. First of, in such the petitioner, the complainant respondent was well aware of the contents of the said agreement regarding possessory right, full stop, yet, comma, alleging falsely that the family of the complainant respondent were deceived by projecting the plot of land as not government land. And issue notice returnable and 4 weeks. A petitioner shall take steps for service of notice upon the respondent by registered post with AD. Having regard to the projection made and considering the documents annexed to the instant criminal petition, more particularly annexer 1 and the complaint annexer 6 contents of the complaint, it is ordered, in the interim that further proceedings of so and so case number presently pending with the court of so and so shall remain suspended till the returnable date.
Deeply obliged, my lord.
25.
May I please?
Yes.
Lordship, the petitioner was facing trial under section 130 of the NI Act. She was present on each and every
How many
day.
times default?
Lordship, only one day, but she
Only
was
one day.
present, but her engaged counsel could not appear because of the heavy traffic.
Heard Miss
A. Hussain. A. Hussain.
A. Hussain, learned counsel for the petitioner, and Mr. B. Sharma. Yeah, go to the affidavit. Enact এটা আছিল না লিখে দিব আর খালি নাম্বারও চেঞ্জ করে দিব Sir, what is the next date? 15/9.
Lordship, 15/9.
2 weeks then. Within 2 weeks you appear. Complaint case number 153/2021. Subdivisional Judicial Magistrate as Roman 2, Kamrup Metro Guwahati. Take amount. You are a sole accused.
Yes, Your Lordship.
Onu Deka. You did not make the complaint in the party.
Lordship,
Okay.
Petition
7/7/2025. Impugn order. What is the ground of your absence?
Lordship, because
Heavy traffic.
heavy traffic due to flood, Lordship. The advocate appeared on time, but the Hazira was not accepted by the learned trial court.
The petitioner has in paragraph 4 the petition has averred as under paragraph 4 to quote for the
Item 26.
May please, Lordship. Also, here I have challenged the complaint petition as well as the order passed by the learned court below.
Complaint petition.
That your Lordship will find at page 24, Your Lordship. Your Lordship, in this case, merely on the application filed by the complainant under section 94 CRPC, which is now 97 BNSS.
97.
7. This search warrant was issued, Your Lordship, and without giving any opportunity of being heard to me.
Yes, Mr.
My lord, in 1907, my lord, if it is some items also mentioned, my lord.
Three
And,
things.
my lord. theft,
One, for the deposit or sale of stolen property.
Yes, madam.
One.
My lord.
For the deposit, sale, and so any objectionable article.
Yes,
Now, subsection 2 has defined objectionable article.
my lord.
And the third is also any such objectionable article is deposited in any place. So, three things.
My lord.
2 and 3 objectionable article. One is
Stolen.
deposit or sale of stolen property.
Stolen.
Do this articles fall?
Here, my lord, in the order, my lord, order of the learned magistrate, my lord, on page 31, my lord, in the third para, he has my lord opinion, in his considered opinion, that the second party amount to amount to theft.
What is the background? What is the background?
It is mentioned, my lord, as a theft item.
Maybe
So, unless 97, my lord, it is-
wrongly. This is street on. She is alleging. How can it be stolen? Normally, it remains with the lady. Lady goes out. Family members of the husband are occupants of the house. There is a street on. There is a different procedure, I think. 97 objectionable articles stolen property. Heard, Mr.
N. Sharma.
N. Sharma, learned counsel for the petitioner. And Mr. MP, B. Sharma, learned additional public prosecutor for the respondent number 1, State of Assam. Post of the respondent number 2 had submitted a petition before the additional district magistrate, Kachar and Silchar. With the prayer to invoke Section 97 of the Bharatiya Nagarik Surakha Act 2023 for recovery of marriage articles to street on. Post of the petitioners herein are arrayed as opposite parties in the said complaint petition. Post of the said complaint has been registered as case number 367/2025. Post of by an order dated 17/6/2025, comma. The additional district magistrate, Kachar Silchar, had in the order, in the MP order, had formed an opinion that the activity of the second party amounts to theft, thus attracts the provisions of section 97 BNSS. Issue notice returnable in 4 weeks. A petitioner, as Mr. Sharma as appears to mention. The petitioner shall take steps for service of notice on the respondent number 2 by registered post UTAD as well as by usual process. Having regard to the provisions contained in section 97 BNSS, more particularly, comma, and the fact that the said provision is exercisable in respect of quote unquote stolen property and quote unquote objectionable articles, comma, and it is ordered in the that the operation of the impugn order dated 17/6/2025 passed by the additional district magistrate Kachar Silchar in case number 367 M/2025 shall remain state till the returnable date.
Item 27.
May I please, your lordship?
Yes, Mr. Ahmed.
Lordship, the against the order dated 15/7/2025, lordship, against the my Zimma petition is rejected.
Yes, Mr. Burwa, call for the case diary. Get the case diary.
Case diary or my report, my lord.
A report, but here is a several, you want the vehicle or
Vehicle,
iPhone also?
iPhone and
iPhone
watch,
comes to home.
lordship.
The question is that, my
Everyone-
lord, vehicle owner is the wife of the petitioner, my lord.
Wife.
And my lord, the other articles, my lord, maybe he is the owner, iPhone and regarding money, purse and other things, my lord.
Two petitioners. Hanifur
petitioners.
Rahman and the wife, sorry, the
Several ATM cards in different names, how can you claim?
lordship, the
Item 7. You are a multifaceted personality or what?
And lordship, may
No,
kindly also see, my lord, the forwarding report, second paragraph, second page, my
I've
lord.
seen.
Yes.
Then you seem to be a dubious case.
the lordship, the
Several ATM cards in different names. How can you claim?
yes, lordship. But no, lordship, the no recovery from my position and the lordship
It
FIR,
is recovered from your position.
no lordship, the FIR lost lordship. The
And,
at the time of,
who
but
is
the
the arrested
footage is
accused
not
person?
available, lordship.
Who is the arrested accused person?
Hanifur Rahman,
Hanifur.
petition number 1, lordship.
You are Hanifur.
Hanifur and the wife, sorry, the
Hanifur. How many cases already?
lordship.
How many cases? Against Hanifur?
The 5 cases, lordship.
Huh?
5.
Come to page 21.
But the said case was the shown.
Para 9. 14 cases.
Lordship, the till date not submitted charge sheet, lordship, against the petitioner.
Because you are veteran.
The lordship,
You are veteran ATM exchanger. International.
no, lordship.
Oh.
Lordship, the Shunerish case, lordship, in the same PS, lordship, the Hatiyao.
Get a
But
report.
till date not, lordship.
But how can you
submit
claim
charge sheet.
this several ATM cards?
In page number 14, my lord, he said that it is not recovered from his position, my lord. Page 14.
Page 14.
Third
Who is the
line,
person?
third line.
Position of Hanifur Rahman. Doubtful. Several ATM cards in different persons' names. You cannot take different names. You can only take one name. One person has taken a name, Amiruddin and Jamiruddin. Yes, Mr. Rahman. How do you claim this ATM cards? Possession. It will be dangerous situation. You limit your claim at this stage regarding the vehicle. Okay, get a report.
My lord.
Heart.
Sonapur, my lord.
When? N. Rahman. R.J. Borua. Assailing dismissal of the petitioner's interim custody petition by the which court, sir? By the Learned Subdivisional Judicial Magistrate S1 Kamru Metro by order dated 15/7/2025. A petitioner has approached this court by the instant petition. Issue notice returnable on so and so date. Date the DD. Yes, tell me.
18/8, my lord.
18/8. Returnable 18/8. Petitioner shall take steps for service notice. As Mr. So and so has appeared, accepted. The issuance of formal notice dispensed with. Mr. Burwal and additional public prosecutor is to shall obtain a report from the IO as regards the articles for which ownership of the articles for which the interim custody has been paid for by the petition, and to place the same before this court on the returnable date.
Item 28.
Lordship, the petitioner has been.
Copies of orders, Thursday.
Under
last day.
negotiable instrument act. Yes, the waste or not, was out of person. That's why.
When is the next date?
4/8/25.
4/8.
Lordship.
How many default?
Lordship, from 18/6 occasion.
Many default. What was the earlier NIA? Yes? 16. Item number 16 again. It was single. 16 perhaps. A default NI case number default. Para 7 was the date of default. Next date 4/8.
There is also some mistake in the order also, my lord.
What order?
Page 15, my lord.
Page 15.
So page 15, my lord, had order dated 18/4 warrant of arrest issued, my lord. Then down below, my lord, it became NBW. my lord.
Last date, Lordship, NBW, page 16, 9/6/25.
But page 16, it is clear.
And page 16 is clear, but my lord, without
Warrant of arrest, I think means non-bailable warrant.
that should have been BWA. my lord.
BWA. Same, huh? Date care, perhaps.
How like that?
Item number 29. Petition for quashing, my lord, because there is no ingredients of section 303 and 106. My lord, your lordship may kindly see page 32. First, my lord, I'm just, before coming to the FIR. The petitioner number 1 is the wife of petitioner number 2, and petitioner number 2 is the chief executive member of the NCL's Autonomous Council. She has a license from the Department of Mines and Mineral for storing, selling and trading of mining
Where
materials.
it is written?
Page 32. 6. He is a license holder. Similarly, there are about 42 license holders in respect from the mineral department. I have annexed those documents. Now, in these circumstances, when that famous rat hole mining, my lord, where many persons have died, so the officials have filed an FIR. That your lordship will get it at page 34. Relevant is at page 36. May I just read this one? This FIR, my lord, ultimately it was investigated by the special investigation team. 12 persons were arrested, all got bail, and now charge sheet has been also filed. This is relating to illegal mining. Certificate copy of FIR. FIR, we need to give it to court. The lecture they talk about. Your Lordship got it. Now, subsequently, this FIR was lodged, and it was registered on the basis of an order from the learned Chief Judicial Magistrate. This FIR is at page 38. Relevant is I think 41. Where is the ingredients of section 303 and 106? 41.
Yes.
Serious incident of illegal rat hole mining, that FIR is already there in existence. Umrangso, which has resulted in the.
No, this is too general, page
Yes,
36.
yes. So
So therefore, my lord, he is a political person. This has been lodged by a political persons. And there is no ingredients of
So
section
we'll not
30.
first examine political person.
No, I'm not there.
Personality of either the informant or the accused.
Yes,
We'll
informant.
first examine the contents.
Yeah, contents. Yes.
Thereafter,
Contents only, yes, my lord.
we go by
Page
the
41.
letters.
Page 41. Where is the ingredients of section 303 and 106?
Rateful coal mining at 3 kilometer area will resulted in the
303 is my lord.
It is.
Whoever commits theft, where is the ingredients of theft?
Let me go through it. This form of mining has been declared illegal by the issued on so and so many based on credible information. It has come to light.
See,
Directly in this.
No, this one, show this.
The transit salam. Issued by so admin has an approved customer purpose.
Wait. Did it? Oh. जो डिस्कस किया था मेरा केस था वो खुद
How the petition? Petition number 2. Petition number 2 is not named.
No, he's there, madam. He's there in the FIR. Page 38.
No, the petition number 1, he has been described as the spouse of petition number 2.
Petition number
But
2.
the specific, page 42. Page 42. Second para. Very specific, the informant.
Page 38, your lordship will
No, page 42. The affair itself.
Yes.
Very specific, paragraph 2.
Therefore, we request you to kindly register a case against Mrs. Kanika Hoja and all individuals responsible for this illegal mining operations and the rest arrest them immediately.
So far, this informant is concerned,
yes,
it is specific to one individual,
yes,
and all individuals responsible.
Yes.
And in the second paragraph, page 41, petition number 2 was never mentioned as an accused.
It is not mentioned. Yes.
The identification of petition number 1 was mentioned as a spouse of petition number 2.
No, then they have.
Yes, that is as per this affair, reading of this affair.
Then page 38, your lordship.
Let us see.
Yeah. Serial 7. Kanika Hojai, and next is number 2 is that petition
Now
number
you can
2.
see.
Then CGM ka hai, CGM code. And there is no ingredients of section. Where is theft money? She is a license holder. She carried something from the mines.
No, I
the
am
challan
not
is
very
issued.
familiar with the new provisions. So
same
let
like
me
me.
check.
Yes, yes. And in the meantime, your lordship may kindly see the
No, let me see. check
challan
the-
also, man. 303,
check
yes.
that. Let me see first 303. What is? Just we'll have a look.
Yes, yes. I am also not familiar. We are getting
303.
familiar.
Here. I don't know. So far 106, there is a
Yes.
case.
Hello?
106.
Yes.
This is the earlier
Causing death of
304A. This is a matter of investigation.
Yes, causing death by negligence.
Negligence.
Where, what I.
This is a matter of investigation,
Yes.
but so far as the petitioner number 1 or 2 may not be there, but
Yes, matter of investigation.
20 persons have
That
died.
already, first FIR, my lord,
So,
already.
what you want, the petitioners may not be involved,
Yes.
but question of 20 dead persons are there, trapped
That is
in
the
a
first FIR.
Hmm?
First FIR, already investigation going on. Charge sheeted, my lord. 12 persons already arrested. First FIR, that is at page 36.
What is this page 45?
Page 45 is, my lord, after the FIR, my lord, second FIR, they went and filed a complaint before the Chief Judicial Magistrate, and Chief Judicial Magistrate has directed for registration of the FIR. And he mentions that about this second FIR also. On the basis
Where it is mentioned?
on the other hand, in the agile detention which is lost by the
What is the earlier case number?
earlier case number is, my lord, FIR number 0225.
Okay.
It mentioned for me.
Yes, let us see.
Yes. On the page 61, your lordship will get last paragraph. And also page 57, it's mentioned, my lord. The last paragraph, 57. The AJR dated 7/1/25 was filed immediately after the incident, and the gist of the allegation is that on 6/1/25 at so and so,
Report submitted.
Umrangso, some miscreants who were illegally extracting coal from well-type pit hole got trapped in the pit underwater. The informant, who is a senior manager, AMDCL, Guwahati, has alleged that the illegal mines were operated without any valid permission from the concerned department. The FIR is registered against so-and-so Mines and Minerals Act against the unknown miscreants and investigated. I have stated in paragraph 6, as many as 12 persons have been arrested and charge sheet has been also filed. How this petitioner is involved? He is involved, petition number 1 is involved in, my lord, purchase of the mines and selling of the same coal on the basis of the license granted by the Mines and Mineral Department.
Where is your the transit pass?
Transit pass, my lord, I'm showing it. This, well, I've given it. Flag, my lord, because
Not part of the record.
it is because certified copy you got it. It is marked one. It is given by the Assam Mines and Mineral Development Corporation. For the purpose of carrying the mines, after purchase it, they carry it and they sell it to suppliers. regarding matlab, death of these 21 persons, it covers by
What is this Garam Pani 3 km? Contractor,
kilometer,
same thing as kilo?
matlab, kilo.
Then what business you are doing in that particular area? 3 kilo
Matlab,
as a contractor?
in that business is matlab, carrying, this is the challan given by the Mines and Mineral Development Corporation.
Get a copy of the case diary. Scan copy of the case diary. Within 4 or 5 days, we'll see. We keep it at the motion stage. Maybe the petition number 2 may not be, but let us examine petition number 1.
My lord.
Because it is noticed 3 kilo. And if km is equivalent to 3 km, then she is the contractor there.
No,
Carrying.
she carries. It is in her name. In challan is in her name. Challan is on the basis of the matlab, license.
No, license is what place? Let us see.
License is at page.
License is to what
Your
place?
Lordship will kindly see page 32.
License, is there any place mentioned?
Matlab,
Any place mentioned?
business.
Umrangsu Bahasa.
Dimahasa.
Let us investigation
And
is
3
proceeded
kilo,
because
3 kilo falls
because
under
the
Umrang.
magistrate has opined at page 57
Yes.
that case records Perus report submitted by so and so, an allegation in first FIR and second FIR are vastly different.
That she says.
Let us have the records.
It is not.
Mr. Borua, can you have the SIT report? Which was
My lord,
placed before the court?
that if it is, my lord, as per my landed senior submitted, my lord, if it is ended in search sheet, my lord, then my lord, we have to call for the.
Search sheet? Okay, which number?
No, bottom to search sheet.
No, we are basically trying to find out the second FIR which can be individually investigated or not.
Yes. But
Or if involves a larger conspiracy, it is a different miss.
yes, that is different thing. But
Omit Shah will not come.
Yes.
And there are many others.
Many other.
Question is whether this affair can be independently investigated upon,
My lord.
or it should be treated as part of the first FIR,
My lord.
as a statement under section 162.
Earlier, fellows.
So second FIR may not be maintainable on the same set of same incident. That is one, right? The earlier one did not indicate any death of something trapped, but it was subsequent.
No.
But it may be part of the first FIR,
My-
or it can be, if it is a case of larger conspiracy, it can be a second FIR also.
No, lordship.
Both possible.
My lord, lordship has to see one aspect of the matter, my lord. First FIR
No,
was
you
lost
gave the
on the
materials.
on the very
I
first
am
day,
not
my lord.
making any opinion, not forming an opinion.
My lord.
Mr. Das's contentions may be correct. And
But
we
what
have to
about
see the
petition of-
perusal of the case report by the OC and the investigation carried out.
My lord.
This area, 3 kilo, there was rat hole mining.
My lord.
And the FIR indicates involvement of the petition number 1.
My lord.
Somehow unnecessarily petition number 2 has been roped in the
Yes.
first part of the FIR. It looks like.
Yes. ma'am. Yes.
I am not,
No, I'm also.
But
My lord,
super
yes.
second FIR indicates the petition number 1's name, whatever, and specifically. So what kind of investigation you have carried out?
My lord.
Because registration is already there, already registered.
Yes, yes.
Can you get the status report of the investigation by, say, Thursday?
Next Thursday, my lord.
We are on
In
Thursday.
respect of my lord, the case
Or
number
Tuesday?
8, my lord.
Huh?
In respect of the second affair, my lord.
Second FIR only.
Case number 8.
First also he can get it by SIT has
No,
been.
it is
on the
already
charge
First,
sheet.
no, my lord, if the
Charge
first
sheet
affair, my lord, is ended in search sheet, my lord,
Yeah.
then scan copy has to be called from, my lord.
Yeah, they will get
That
it.
will be,
get the
no,
scan.
that will have to be called
No,
for.
that
today's
will
day, my lord.
require some time. But investigation, status report of investigation, you can get it by Tuesday. or
Let him Thursday, my lord.
Thursday? I don't know.
Thursday, what?
Thursday I'll be sitting in the second half only,
My lord.
not in the first half. Tuesday I can do.
Or
Make an
Wednesday also.
endeavor,
My lord.
make an endeavor on Tuesday.
My lord, my lord.
Let him make an endeavor.
My lord.
A status report.
And why petitioner number 2?
That
Why petitioner number 2?
at least I am primarily satisfied about petition number 2. But
And petitioner
not
number
in
1
piecemeal.
also, she is just doing work on the basis of the license.
Let us
How
have
can-
a privacy satisfaction.
Yes.
So whereas petition number 2, at least privacy satisfaction is there, that it was not indicated towards FIR was not against petition.
Yes.
Mr. Heard Mr. B.D. Das, Senior Counsel, Estate and Mr. D. Learned Counsel for the petitioners. And Mr. R.J. Borua, Learned Additional Public Prosecutor for the respondent state. Full stop.
Okay.
Having regard to the issues raised with regard to the FIR, registered as
08/2025.
08 or 07?
08.
08, 2025.
0008/25. It's
Okay, 08, which police station?
Umrangso police station.
Umrangso Police Station, case number 08/2025, the Mr. Borua shall obtain a status report of investigation on the said case shall make endeavor and to place the same before the court on Tuesday.
Tuesday to keep 4th of August.
5th, Monday to Tuesday.
Monday, so till be Tuesday. Tuesday is 5th August.
5th of
5th August. Only 2 days in between.
Yes, yes. No issue.
Item 30.
Oh, meeting আছে। এইকেইটা কালি এপিল কেইটা কালি দি দিব লাগিব। 31 ৰ পৰা 37 কেইটা কালি দি দিব লাগিব। এপিল কেইটা কালি দি দিব। কালি কিমান আছে? Yes.
Yes, Lordship, I am against issuance of warrant by rejecting my petition of absence on medical grounds. I like to draw your attention on the page 21 of the Annexure 5, Lordship, my petition, Lordship.
POXO case.
POXO case, Lordship, 12 and 15.
12
and 15.
section. All throughout present, either in person or through so by taking steps. Single occasion to say 7/7/2025. So till the next date 21/7, the NBWA will remain under suspension.
No, next date is 4/8, Lordship.
Huh?
On 21/7 is the impugned order, Lordship. 21, page 21 is the impugned order, Lordship.
21.
Next date is 4/8, Lordship, for appearance of
4/8. 4/8. It will stay for you. Dispose of. The other, can it be inconvenient for you if I post all these appeal 31 to
My lord,
37 tomorrow?
my lord, I am for the 31, my lord, because statutory
Madam,
appeal, my
madam,
lord.
please hear me out. So
Sorry.
I have to attend a meeting also. I have to take balance 31 to 37. Can we post it tomorrow?
Okay.
And at 10:30, I'll take up.
Lordship,
And
37,
10:30.
37, can it be on Monday? Some difficulty tomorrow.
37.
Yes.
Okay, 37.
37 to Monday.
Okay, 37 to Monday. Are 31 to 36 tomorrow?
My lord, 36 also, my lord.
Tomorrow?
After 8th August, my lord.
8 August.
8th August, my lord.
These are statutory appeal.
Appeal, my lord.
Only to be
I have some medical
and
issue.
wherever.
Tomorrow, my lord, I have some medical issue, my lord.
Give somebody. Give somebody. I'll take care of it. I'll take care of it. Give somebody here at 10:30.
Lordship, item number
31 to 30. 6.
Lordship, item 32, there is an IA, Lordship, that may come along with the main matter, Lordship. IA 798, Lordship, it has been numbered. IA 798 of 2020.
Yes, that's yes. Yes. Next.
Lordship, item 38, Lordship. Lordship, we have an interim order, Lordship. I pray that may be extended to the next date of hearing.
CBI, madam.
Please, your lordship. This is a matter with regard to the PC Act. So though the order of the stay has already been granted, but there is no as such provision in the PC Act to stay the proceeding of the trial court. And moreover, the trial is not yet started, only the charge sheet has been filed. How a stay can be granted?
That is a different matter. We are regarding fixing the date.
When your
Due to
lordship.
paucity of time could not take up. So
No
how?
problem, no problem.
So R. Borua,
Lordship,
petitioner.
E. Borua for the
E.
petition.
Borua, petitioner. M. Kumari.
M. Kumar.
Let's counsel for the respondent. Pending also.
I'm standing counsel of the CBI.
CBA are present. We put it on 13th.
13.
Next week, actually, I have some, I'll be sitting on and off.
Then maybe on 14th, one matter is already here on 14th. So it
So
would
that
be
will be difficult. I have fixed also 14.
13. Okay, no
13
problem.
or you
13.
can take 9,
13, no
9,
problem,
sorry,
Lordship.
18.
Lordship, 18th, Lordship.
18th. 18?
18th, my lord.
Interim order.
18.
Continue. Any other? Okay.
Much obliged.
Hey, Pranbara Sahotu.
It is.